I'm reading it as we speak, Judge. And good morning, and may it please the court. I've had a chance to review the motion, Your Honor.
Thank you, Attorney Phelps, and we will take up the motion that was filed this morning first. You may be heard on the motion.
Thank you, Your Honor. Maybe I misunderstood yesterday when Ms. Almeida was testifying and she was explaining what she said, and I had objected on the grounds of hearsay, and I believe that Your Honor had indicated that because she was present and able to be crossed, that it did not constitute hearsay. If there's another reason why it should be admitted because there's an exception to the hearsay rule, or it's not hearsay because of something other than the fact that she's present and able to be crossed, that I understand. But I would like to ensure that just because she is here, that does not mean anything that she had said outside of court constitutes non-hearsay.
Well, this is a motion in limine to preclude certain evidence that the defense considers hearsay. And the court is not inclined to rule in the defense's favor on a motion in limine to preclude hearsay statements because as those statements or as those questions are proffered, the defense has an opportunity to object. The court will take up the objection when the objection is made.
Thank you, Your Honor.
Our counsel prepared to argue the motion concerning the STR mix evidence.
Yes, Judge.
Thank you. First, the court recalls that the defense had indicated that it would essentially challenge the STR mix evidence by way of a Porter hearing. First, is that the defense's position today?
I've had some opportunity to discuss this with Mr. McGinnis. I am not seeking to preclude any evidence from the STR mix program. I've had a fair amount of opportunity to research, read up about it. My claim is more narrow, that there needs to be a Porter hearing on the so-called likelihood ratio. I'll just be clear on what I'm not challenging. I'm not challenging the fact that this program does what's known as a deconvolution analysis. It takes what is essentially multiple depositors of DNA and runs a number of odds, for want of a better term. In other words, it takes mixed DNA, that could be anywhere from 2 to 6, 7, 8 different depositors of DNA, touch, any kind of fluid, anything that sneeze, anything that has DNA in it. It determines, based on certain input by the lab assistant, that they determine how many contributors they estimate. This program then runs statistics, thousands, hundreds of thousands, I think in some cases, millions of scenarios, and comes up with odds, and that's why I'm challenging this part of it. What the odds are that one scenario, that is the prosecutor's theory, is more likely than the defense assumed theory. Again, they don't necessarily know what our defense theory is, but they put in a suggestion that maybe it's someone else's or it's a third party's or whatnot. So this program, which is proprietary from a New Zealand company and no one has access to, again, the only scientific studies of validity have been conducted by a team that's made up of the company's vice president. There has been no independent study. And I'll just say this. The PCAST report, that is the President's Commission on the Admission of Scientific Testing, concluded in 2020 that STR mix has promise, but there are no scientific validity peer-reviewed studies. There are only studies that have been conducted by the company itself and people that they themselves have brought in. So the only portion for this hearing and for this trial that I'm challenging are the odds. In other words, this computer runs I think it's called the Markov Monte Carlo analysis algorithm. It's the same, not exact algorithm, but the same process that's used to calculate the odds of winning the lottery, the Powerball, when it's $1 billion. So the problem with that is that just because they're giving out odds doesn't mean that only 1 in 1 billion people could win. If that were the Powerball, if that were the case, that if it happens that 2 people guess the numbers, the misconception is that, well, someone must have cheated, someone must have gotten the numbers in advance because the odds were 1 in 1 billion, and here 2 people in 1 billion got it. So my concern has to do with these numbers. These are not these numbers do not mean that it's 100 billion or 10 billion or in one case, 250,000 to 1 that a particular DNA profile may have been the source of a mixture on a sample. Instead, what it is it's the odds that the person's DNA is on there as compared to X number of other unknown persons, even if the other people were known. And the problem with that in this case is that there are going to be, some of these tests are going to show that, for example, all of the children, all the Dulos children are included in some and are partially included in some. So we've got this problem, and that's the reason for the Porter hearing, which would require the witness to substantiate, and I would then cross-examine about the lack of peer review of the odds. We're just talking about those numbers. In the past, Your Honor, I'm sure has had cases where the DNA lab has said someone's included, someone can't be excluded, or something is inconclusive. And inconclusive, according to the laboratory, is that it's too small a quantity, or it's too many contributors, it's too convoluted, therefore there's a high risk of error. So they say it's inconclusive, has no validity. So there are those 3 potentials: included, cannot be eliminated, which I think they recently changed to consistent with the sample, but is lower than included, and inconclusive, which they say is, they can't make a determination. The thresholds are too low, too much chance for error, so and misidentification, so they call it that. I am only challenging these odds that the computer program has calculated based on this the Markov chain Monte Carlo algorithm, because it's just based on a computer program calculating odds. And I believe the only case in Connecticut is the one that this lower court case that was cited. I'm not seeking to call experts that beyond using the laboratory personnel as the basis for that. But I'm just indicating that because there's no appellate level case in Connecticut, and the cases from elsewhere have only dealt with whether the program itself has any validity, and it has at least the program they've used. In those cases, they've used known samples, let's say of lab personnel, and they've run the program and it's come out correctly. That's not the same thing as a peer review of the odds that it was correct. And that's the problem I have. It's assumptions that are programmed into it. So I don't know how the court wishes to proceed, but the state is the proffer of this evidence, and I'm suggesting that we need some evidence, maybe a half hour to an hour, I don't want to preclude the state from putting out more than that, but based on my understanding of what I intend to elicit, I don't think it's going to take more time than that.
Well, the court has this question first based on counsel's explanation. The first question is, how can you deconstruct the STR mixed software from what it produces, which is the likelihood ratio? The second question is, it appears counsel's argument is not that the STR mixed software producing the likelihood ratio predicts the right odds. It's just that the odds that counsel believes are not correct are not subject to peer review. In other words, this set of odds versus that set of odds. That's how the court understands the argument. Not that there are no odds that should be calculated at all.
So, poignant observation, Your Honor, but let me just say this. The program itself is mysterious. No one that I have consulted with or cases that I've read can testify as to how this program operates. It's proprietary, it's secret. They have refused to release it, except I think a federal judge allowed an expert to review it, but only by promising that they could not divulge to anyone else what they saw in this program. That's my understanding of how this works. So to answer your question directly, I believe that because no one knows how the odds were calculated, and they're not done by the expert using a calculator or a chalkboard like I saw in the movie Oppenheimer, where they're figuring everything out on a giant chalkboard. It's just somebody punches in some numbers and the computer runs for 5 minutes and it spits out percentages and odds. What I'm not challenging here are what's called the deconvolution. That's the portion that separates out how many different people they believe are in it, and some may be a stronger than someone else. I'm challenging the numerical odds, which is all it is. It's percentages that this computer program is saying, how much more likely are the odds that the sample that's been deconvoluted as a principal or majority source, because they don't know how something got onto a particular object. We're not talking about blood here. I want to emphasize we're talking about touch DNA, skin cells, which is my understanding is as little as 3 cells, which is approximately 22 or 21 picograms. And just for the court's edification, a picogram, 6.6 picograms is 1 cell. A picogram is a trillionth of a gram. So we're talking about something that is so tiny that it would require an electron microscope even to see. So I'm not challenging any of that. It's the calculated odds that those trillionths of a gram of DNA are more, the odds, the number, is more likely from one source than an unknown source. And I suggest that that's for litigation purposes. It's not a scientifically reliable calculation.
Well, as the court understands the argument at this point, the question that solves the mystery is, what equation did you use, proprietary entity, to come up with the odds that you have calculated? They know the equation that they have used. And the extension of that argument, as the court understands counsel's argument, if you know the equation and no one else knows the equation, how could it have been peer reviewed? Correct?
When you say you, you mean the company in New Zealand. Yes, that's right. That's exactly right. It's sort of like, I'll use an analogy, an everyday analogy. right on my screen right now is a image of looks like a desert scene with a road. That's the screensaver. That's made up of millions of pixels. I could tell you somebody obviously took a photograph, maybe in, it says North Africa in the corner, so I'll accept that as the screensaver on my screen here on my desk. But I could not describe the program on how a computer took a million pixels, put it together so that it would show up on a screen. Someone knows how to do that, and someone could testify to that. We're not here to challenge that, but it's the same concept. It's a secret that only this company knows, and it keeps it so well protected so that no one else can copy it. And if nobody can copy it, it can't be peer reviewed whether it's accurate.
Well, isn't it possible that there can be a peer review without disclosure of certain proprietary information?
An interesting question. I don't know the answer to that. However, enough cases I've read on peer review means it was reviewed in a scientific journal that anyone in the scientific community can review, and they have a peer review group that then writes something saying, yes, we reviewed the algorithm, we tested it out, we used scientific method, and we find that it meets the standards of scientific, the scientific standard that we can substantiate it. I'm referring to the Presidential Commission that said, you know, it's an interesting concept, but we have not seen any independent review, and they criticize the fact that the only reviews that are out there are by a fellow named Buckleton, who's a corporate vice president of the company that he came up with it. He's doing his own self-substantiation, which they said does not meet the standard. So that's all I'm going on. Now, if we wanted to take even more time, I could challenge the entire process because it has not yet been fully reviewed. But I'm limiting for our trial here because of the fact that there's so little DNA that's in any contest at all here in terms of whose it is or whose it might be. And that's why I'm limiting it to the issue of the odds, which I submit. Well, because I can't cross-examine that because nobody knows, including the lab scientists, how it came to that conclusion. It will be confusing to the jury. They will, as inevitably will occur, think it has more significance, these numbers, than they do. You know, they're as high as, the odds are as high as 100 billion to 1. I'll just note, even the warrants that the police applied to misapplied the findings when they stated somebody was a match or not a match. That's not what it even does. But again, I'm not here to criticize what the police did, but if the police got it wrong in the warrant, in some of these warrants, the jury's going to get it wrong. And that's why we need to establish, I believe under Porter, the court is a gatekeeper to decide whether it has relevance, whether it can be explained or even cross-examined, and whether or not it will be of an aid to the jury or perhaps will be confusing, and therefore maybe the prejudice would outweigh any probative value. So that's the purpose, and it's limited to that. But I think the state, as the proffer, has to make the proffer in the first place. Whether it's done partially in front of the jury and then we excuse the jury, that's up to your honor. But the state has the burden of showing, and the fact that there's one Superior Court case by Judge
Didabo,
that allowed it in. That was not the challenge. It did not have to do, that was the challenge to the whole program on whether it was reliable. I'm not doing that. I'm only challenging the use. If the state wants to exclude the use of these, the likelihood ratio, and I emphasize, it is not a scientific result. It's the likelihood that the state's theory is more likely than the assumed defense theory to the contrary. So it's calculating odds. It's not calculating science.
well, what the court is going to refer to is Judge Didabo's decision because the court is not persuaded that the likelihood ratio calculates the likelihood of the state's theory against the likelihood of the defense's theory. The STR mix software produces what is called a likelihood ratio. Now, a likelihood ratio expresses the probability that a match between a sample and an individual is X times more likely than coincidence would have it. The STR mix is more likely to yield a likelihood ratio favorable to including true contributors to a mixed DNA profile and favorable to excluding true non-contributors to that profile. So how does the probability description, the likelihood ratio, favor the prosecution rather than the defense if the favoring goes to both inclusion and exclusion? That's a question for Attorney Shulman.
Let me give the court just one example. When it comes to certain samples that are of the known sample of Jennifer Dulos, they used a toothbrush, for example, from the bathroom, master bathroom in New Canaan. The STR mix calculated the odds of that being Jennifer Dulos's DNA of 1 in 100 billion to 1. So 100 billion to 1 that the contributor to that DNA sample was Jennifer Dulos versus an unknown third person that they just assume is like an unknown third person. Now, there aren't 100 billion people on Earth. So the only conclusion one could reach is that the only person who could possibly have contributed that sample is Jennifer Dulos. But that's not something I'm contesting about her toothbrush. Much of the samples are partial DNA. They don't even have a match. So the problem is the machine and the calculation is adding fake alleles and is saying, well, if we add this one, then if we add that one, if we add that one, but it's doing multiple, and I mean millions of calculations. If we add in this allele, what are the odds? If we add in the next allele, what is it? If in a different locus on the DNA strand, we add this. So it's doing all this, and then it's calculating odds. Now, if it's less than those odds of 1 in 100 billion, there is a threshold where the lab will say, this is too low, it's too unreasonable, we may not be able to exclude somebody, but even if there's only one allele, that person may be included because of that. And the problem is it's too easy for a jury to think, well, if one allele is in there, and if the defendant, or for that matter, Fotis Dulos, is included in that, then it must be him. And the problem is there's all these issues with the children matching in some cases. In some of the children match, as I'm not objecting to all that. There's a PowerPoint that I don't know if Mr. McGinnis is going to put in. I'm not objecting to how DNA, it's how you inherit from each parent, et cetera, et cetera. So this is all science that I'm not objecting to. So there's a lot of this that's going to come in. The only thing I'm challenging is they're not going to say it's a match. They'll never say it's a match. They will say it's 100 billion to 1 more likely that it comes from that toothbrush than it is that if it was a totally random person. And again, since there aren't 100 billion people on Earth, this calculation is what's prejudicial, not the fact that they said that they say that it's consistent with, or the DNA matches the individual. That's my point.
Well, of course, peer review is only one basis for determining whether a methodology is valid. How would you respond to the argument, Attorney Schoenhorn, that the STR mixed software, which yields a likelihood ratio, is better than the extraction amplification method?
What's interesting about that, Your Honor, is that's what Mr. Ladd testified to at that hearing, according to what I'm reading. I don't know if the court would reach the same conclusion about that. The challenge to the extraction method requires a fair amount of individual assumption and eyeballing by the scientists. There are, of course, videos, there are photographs. If one wished to challenge that process, one could, although that's been established over the years. That's going back 20, 30 years. They've had electrophoresis. The lab person will take I think it goes back to when Your Honor was practicing law. There would be a form of, they would run a sample through electrophoresis. They would determine peaks and valleys and come up with a DNA profile from that. If it was a mixture, it would be a estimate based on the particular lab assistant's proficiency as to whether that was 2 or 3 or 4 individuals. I'm not, in this case, challenging the manner in which they have extracted the DNA. They recently changed. They used one program. More recently, they just started using it, and I understand that just in the last month they reran my client's DNA, and the numbers came out lower than in the previous one. So again, I'm not going to challenge, especially since those numbers are more favorable, but be that as it may, I'm not getting into the challenging of the extraction method that's been used for 15, 20 years. They changed from one brand, one company that they use to another. There's been a number of hearings on that over the years, a number of cases on that. So I don't know if I agree with a conclusion by a coordinate judge that that's better than the extraction method. I don't agree because there's, other than Dr. Ladd saying that at that hearing, I don't know of any independent analysis that says that. That's my response.
How would you respond, Attorney Schoenhorn, to the argument that the peer review doesn't go to, we will call it the exactitude of the odds? The peer review goes to whether STR mixed software is just better than extraction and amplification. That's what was peer reviewed, not the component parts of proprietary information.
Well, it's, to my view, and again, I'm not a scientist, but in reviewing this, I think it's apples and oranges, because the extraction is a completely different method, a different program. So if one is saying that, I don't know, a program like Photoshop is better than a PDF program that also can create photographs, I don't speak to that. The difference is, does the program that creates the photograph, is it better than a program that calculates the weather patterns for the next week? So I can't compare the two. The fact that Mr. Ladd likes it better, since he doesn't know, as I understand, that he doesn't know how it operates, the fact that it's more efficient for his purposes doesn't make it, quote, better, unquote. I don't know how else to answer Your Honor's questions. I mean, I understand Your Honor's concerns, and I'm trying to meet them, but I don't have that expertise. I can only go back to the fact that the state, we have a lower court opinion. It was not appealed, that case. And So therefore, if the court is just going to adopt what another judge says, at least the court needs to have reviewed the transcripts. I mean, I'll say what I wanted to be perfectly candid about this. The Nunez case was my case. I was there for that entire case. I don't know if Mr. McGinnis knew that, but that, you know, I mean, I know that I did this like 3-4 years ago, had a hearing, but in that case, it was still brand new. I challenged the entire use of that program. There were only 1 or maybe 2 cases, and some had rejected it, one had rejected it, and one had permitted it, but never got to the issue of the putting in the numbers of the likelihood ratio. And we're talking now just about those numbers. That case was an alleged sexual assault. It resulted in acquittal, so there's no appeal, no appellate review. But I'm just letting the court know, I'm not speaking like I'm just reviewing a decision. I was there. I spent many hours with Dr. Ladd, but the issue there wasn't the numbers. It was the program itself being convoluted, for want of a better word.
Attorney McGinnis.
Good morning, Your Honor.
Good morning.
Judge, of course, we do object to the motion for an order hearing. I think that this, Your Honor, can succinctly be rejected on a couple of different grounds. The first is that at this point, STR mix, as we stand here in 2024, is generally accepted in the scientific community. And I'll rely primarily, Your Honor, on our memorandum of law or objection in opposition to the defense's motion for a order hearing. The cases that we cited, Your Honor, extensively detailed the reliability of the STR mix. And in fact, the only case that the state was able to find in which the STR mix was initially rejected as unreliable was subsequently reversed by the Sixth Circuit. So as near as the state can tell, if this court were to find that STR mix is unreliable, you would again be the first court in the country to do so, because the one decision that found so no longer stands. So if we look at State versus Rayner, which provides the court with guidance on how to handle a motion for a proposed order hearing, number one, if the court finds that STR mix is generally accepted in the scientific community, then the burden shifts to the defense to produce, and Rayner describes it as a heavy burden, to produce some evidence that calls into question the scientific validity of STR mix, and they haven't done so in this particular case. The PCAST report that Attorney Schoenhorn mentioned is from 2016 and was actually in front of Judge Dodavo at the time that he made the decision in the 2019 Nunez case. The court will review Judge Dodavo's decision. It was entered in as an exhibit, specifically Defense Exhibit A. So once the court finds that this is generally accepted in the scientific community, the defense fails to meet their burden. But even if the court disagreed with the state and decided that it wasn't generally accepted within the scientific community such that it's reliable enough for admissibility, Rayner gives even additional guidance which cuts against a order hearing in this instance. And that additional guidance says the court can take judicial notice of Judge Dodavo's opinion. You're not required to do so, but you can take judicial notice of Judge Dodavo's opinion. And one of the things the court can consider when taking judicial notice of Judge Dodavo's opinion is whether or not the defense has produced any new information which calls into question Judge Dodavo's opinion. Now, respectfully, the defense has not done so in this particular case. They haven't even admitted the actual PCAST report for purposes of this hearing that was in front of Judge Dodavo as part of their profit. So the defense, frankly, Your Honor, has done nothing to call into question Judge Dodavo's opinion except try to distinguish Judge Dodavo's opinion and say, even though I challenged the entire software back then, I didn't challenge the likelihood ratio portion of it. That makes no sense. If you're challenging the entire software, you're necessarily challenging any data that software produces. And so frankly, Your Honor, I think that this can be very easily disposed of because, number one, the cases that we've cited to the court show that this is generally accepted in the scientific community. And number two, Judge Dodavo has already subjected this to a Porter hearing, and the defense has done nothing to call into question Judge Dodavo's opinion here as part of their proffer. So I'm asking that the court exercise its discretion under Rayner and deny the defense's request for a Porter hearing, and let's get on with the trial.
Thank you. The court has had an opportunity to review Judge Dodavo's decision. The court has had the opportunity today to listen to the arguments of counsel concerning the validity of the methodology that yields a likelihood ratio. The court's first consideration, just based on the representation by defense counsel, the first concern the court should say is the court is not clear on how the STR mix software can be valid, but a component of it not be valid. If A plus B plus C equals D, how can A plus B equal D without C? So the court is not clear on that argument. Concerning the Porter factors themselves, there are a number of factors that are considered. According to the case law, the weightiest of which is acceptance, general acceptance in the relevant scientific community. So the list includes general acceptance in the relevant scientific discipline. The methodology has been tested and subjected to peer review. There is a known or a probable rate of error. The prestige and background of the expert testifying about the methodology, and whether that expert's opinion about the methodology is based on his or her subjective opinion or is based on verifiable objective criteria, and whether the expert can explain to the jury methodology well enough for the jury to understand how to apply it to the facts of the case. Now, the finding in Nunez was that the STR mixed software is generally accepted in the relevant scientific and legal community. The finding was that the methodology was tested and peer-reviewed, and the known or potential rate of error was low. Judge Dodavo concluded that the expert witness was highly competent and was capable of presenting the data and processes to the fact finder in a way in which the fact finder could reasonably use the information to make a decision. The court is relying on Rayner. New information coming to this court's attention was only in the form of the PCAST report, which indicated, as the court understands it today, that the calculation of the odds is a mystery and it cannot be, as a mystery, peer-reviewed. That's how the court distilled that information. That is not enough information for the court to require a Porter hearing. So the court denies the request for the Porter hearing. Are we ready to proceed with the state's witness?
Yes, Judge.
Your Honor, when the witness comes in, if Your Honor could please request that she keep her voice up so everybody could hear it, appreciate that.
Thank you.
Thank you.
Well, let's see if she's going to keep her voice up anyway.
Thank you, Your Honor.
Thank you. Well, first, let's bring the jury in. You can hold the witness right there before the jury comes in, please. Will counsel stipulate to the presence of all of the jurors?
Yes, Judge.
Yes. Good morning, ladies and gentlemen.
Good morning.
We resume with the testimony of the witness you last heard from yesterday evening. And you are still on the rope. You may take a seat. Thank you. Attorney McGinnis.
Good morning.
Morning.
Ms. Almeida, if I were to show you a photograph of Jennifer and another photograph of Jennifer with her children, would you recognize the individuals?
Yeah.
May I have these marked, Your Honor?
Has counsel seen them?
I have Your Honor.
I'm handing you what's been pre-marked for identification as State's Exhibit 15 and State's Exhibit 14. I'm just going to ask that you please begin by looking at State's Exhibit 14. What is that photograph of?
It's of Jennifer.
And approximately how old is Jennifer in that photograph?
Well, it looks like she has Noelle next to her, so she was maybe in her late 40s, early 50s.
Ms. Almeida, it's difficult to hear you.
Oh,
So would you
sorry.
please keep your voice up?
Yeah. I would say her late 40s or early 50s.
Judge, I move it in.
No objection.
The number again, please.
State's 14.
Stage 14, admitted as a full exhibit.
And now just directing your attention to State's 15. Can you tell the members what's depicted in State's 15?
Yeah, this is a picture of Jennifer and the 5 kids.
And how old are the children in that photograph?
If I had to guess, I think maybe Christian and Constantine are 6 or 7, and the boys are 9 or 10, and Noelle 3 or 4. And it looks like they're in a classroom.
And move it in, Judge.
No objection.
Stage 15, admitted as a full exhibit.
May I publish to the jury, Judge?
Yes. Well, it's going to take a long time to do it that way, Attorney McGinnis. You should hold it up and show it to the jurors.
That's fine, Judge. Thank you, sir. Publishing States 15 and 14. Where we left off yesterday, Ms. Almeida, you had indicated that you were familiar with the defendant. Is that correct?
Yes.
Where did you meet the defendant?
In Miami at the ski club.
When did you meet the defendant?
March of 2017.
How long after your arrival in Miami did you meet the defendant?
Probably like the next day or a few days after, because we went right to the ski club.
And can you describe the ski club for the jury?
There was like a gate that you kind of drove in, and then there was everyone's boats like kind of in like a port, and they would take out the boat to go into the water. And it was a pretty narrow like lake, and it was used for water skiing. And there was like a little outdoor area that had a tent and a table that you could hang out in if you weren't skiing.
Was it a public ski club or was it a private ski club?
Private.
Did Mr. Dulos own a boat?
Yes.
When did he purchase a boat?
I'm not entirely sure the exact like month, but I think it was like maybe 6 months to a year prior to that trip in 2017.
What type of boat was it?
I don't need a ski nautique. I might be getting that wrong. It was a ski. It was made for skiing. So
Where did he keep the boat?
in Miami.
And would he travel to Miami?
Yeah, often. Yeah.
And did he keep the boat at a particular place in Miami?
He kept it at the ski club.
When you met the defendant, was she with anyone else?
Her daughter,
And what's her daughter's name, if you recall?
Nicole.
Approximately how old was her daughter at the time?
She's the boy's age. The 17-year-old boys now. So maybe 12, probably 11, I think, around that age.
Did Jennifer ever go to the ski club in Miami?
No.
Where would Jennifer stay if she wasn't at the ski club?
Well, her mom was visiting at the time too. So she was with her mom at the hotel or with the youngest, Noelle, who would come to the ski club sometimes, but not as much as the other kids.
How many times while you were in Miami during this March 2017 trip would you say you were in the defendant's presence?
A few times.
Who introduced you to the defendant?
Fotis.
Did Mr. Dulos introduce his children to the defendant as well?
Yeah, I think prior to that trip.
Okay, when you say you think prior to that trip, can you explain to the jury what you mean?
Yeah, so when we got there, they were calling her Mitchie. And they hugged her. So like they already knew her. I believe it was just the two boys. So Petros and Theodore. I don't think Krishan and Constantine or Noelle had met her yet.
Would Mr. Dulos travel to Miami with the older boys, Petros and Theodore,
Yeah.
prior to this trip to Miami?
Yeah, prior to this trip.
Can you describe your interactions with the defendant at the ski club for the jury?
Yeah, so Fotis introduced her as a friend, and she was nice. She was with Fotis a lot, like they'd go on the boat to ski, but there was one time I had a conversation with her when we were underneath the little tent where you can kind of just hang out. I remember the conversation. She was telling me she just got back from Colorado. She was looking at schools for her daughter to go to because her daughter was a very good snow skier. So she wanted her to, I think, get better or more opportunities there, I guess. But she was friendly.
When you interacted with the defendant, what language did you speak to her in?
English.
Did she have any trouble communicating with you in English when you spoke with her?
No.
Did the Dulos children interact with the defendant's daughter, Nicole?
Yes.
And I want to direct your attention specifically to Petros. What was his interaction with Nicole?
It was kind of known that maybe Nicole was his girlfriend. He was 11, but in that sense.
Was Jennifer ever in the defendant's presence during the Miami trip in 2017?
No.
Did Jennifer stay in Miami with the family for the entire trip?
No, she didn't.
Can you describe to the jury or explain to the jury why Jennifer did not stay in Miami for the entire trip?
So her mom was with us, like I mentioned, and she tripped and she ended up breaking her ankle. So they had to fly back early so she can get it taken care of. And she took Noelle with her. So they left a few days before the trip ended.
Where did her mother trip?
I think it was by the pool. She slipped.
And when you say by the pool, which pool are you referring to?
Oh, the pool in Miami at the hotel.
And just to remind the members of the jury, what hotel were you staying at?
The W?
And if we can be as precise as possible, approximately how many days were you in Miami before Jennifer left?
I think it was like 2 or 3 days. So it was towards the end of the trip.
And after Jennifer left Miami, who stayed behind?
I stayed with Fotis and the other 4 kids.
Did you guys ever go to the ski club again?
Yeah.
And was the defendant present?
Yeah.
Did there come a point in time when you were no longer staying at the W?
Yeah.
Can you tell the jury what happened?
There was one night where Fotis said that we had to stay in a different hotel, and so we drove to the Ritz-Carlton, but it was only going to be me and the 4 kids, and so because he was going to stay with a friend, and he didn't really go into specifics. It was just kind of odd, but I just agreed, and so it was the 4 kids and myself, and we stayed in one room together for that one night, and then we had to get up at like 5 a.m. to get an Uber to meet him at another ski club.
And when you say all of you stayed in one room, how many beds were in this room?
1 bed.
Where did everyone sleep?
We squished on the bed. I think I was with Christian and Constantine in the bigger bed, and Theodore was probably sleeping. We had a cot, and then maybe someone on the floor.
When Jennifer was in Miami, were you all sharing a room like this?
No.
What were the arrangements when Jennifer was in Miami?
Objection relevance.
Well, court does not know if this is preliminary to a more material matter. The court will overrule the objection.
What were the arrangements prior to Jennifer leaving Miami?
We had more of like a suite room, so there was multiple bedrooms, so that way there was more space for us to be, and like a common living space and a kitchen space also.
Did you ever see the defendant outside of the Miami Ski Club?
Yes.
Where did you see her?
We went to laser tag one day.
Approximately what time did you go to laser tag?
It was after the ski club, so it was probably like later afternoon into the evening.
And what type of facility was this?
It was like one of those places that had an arcade and a pizza and laser tag. I don't remember the name.
When you got to the facility, can you describe to the jury what happened?
Yeah, so I went in and I just kind of went right to the register to like pay for everyone. And Fotis kind of ran in after and he's like, no, you can't, like, he wanted to like make sure that he was the one paying. It was just kind of odd, or have Michelle pay. It was just a weird interaction. And I just told him, I don't want to do laser tag because I was tired and I didn't want to play laser tag. And laser tag with that many kids is very tiring. But he was pushing me to play laser tag, which was just kind of weird. So I ended up having to play laser tag while Michelle and Fotis hung out outside of the laser tag room.
And I just want to be clear about this. When you say he was pushing you to play laser tag, who are you referring to?
Fotis.
And where you indicated that they did not play laser tag, they being the defendant and Mr. Dulos.
Yeah.
Where did they stay while you were playing laser tag?
Well, because it was like that arcade kind of space. There were tables and stuff that you can kind of hang out on while the kids were in laser tag.
Was anyone else present besides you, the children, Mr. Dulos and Michelle Troconis?
I think Nicole was there also.
And did she play laser tag?
Yeah.
You indicated earlier that Mr. Dulos did not spend the night with you at the hotel when you were with the children after Jennifer had left. Is that correct?
Yes.
Did Mr. Dulos strike that? Where did you end up meeting with Mr. Dulos after spending the night at the hotel with the children?
We went to a different ski club in Boca. So we took an Uber there to meet him there in the morning.
And was the defendant present at that ski club?
No.
When did you leave Miami?
Shortly after that, we took like an evening flight because we got in around 11 and we weren't back to their house in Farmington until about midnight.
Who was on the flight with you?
Myself and the 4 kids.
Mr. Dulos did not travel back with the family?
No, he extended his trip.
How did you get back from the airport to, I assume, Fort Jefferson Crossing?
We took an Uber
And what time did you arrive?
around midnight.
When you arrived, what did the children do?
Oh, they were all tired, so they like ran upstairs and like got into bed. So
Do you recall what day of the week this was?
I don't.
Was Jennifer awake?
Yeah, she greeted us.
And did you speak with Jennifer?
I did.
Did you spend the night at the home that night?
No, I went back to my home.
Did Jennifer discuss with you a belief she had about Mr. Dulos?
Yes.
What did she say to you?
She told me he is having an affair and I have proof.
What was her proof?
I think through email and receipts, she found out that he went on a trip to Utah with Michelle and a friend of his and his girlfriend.
What was her demeanor like as she said this?
She was, I think she just was just like, I knew it. She's again, very soft-spoken. So she seemed sad, but also just kind of like she was trying to figure out what to do.
Did she indicate to you whether or not she was going to be confronting Mr. Dulos about the affair?
She told me that she was going to talk to him about it, and she asked if I not mention anything.
Hearsay.
Well, the court's concern is relevance. So this appears just to be a series of events that, of course, the jury is hearing this testimony, but it just appears to be a series of events. And the court is going to keep a short leash on this chronology because it has to lead somewhere. So the objection is overruled as far as hearsay is concerned. The court's concern is relevant. Overruled.
You can answer the question.
Can you repeat the question?
I will try. Did she indicate to you whether or not she planned to confront Mr. Dulos about the affair?
Oh, yeah. She asked me, well, she told me that she was going to, and she asked me not to mention anything to him or to anyone.
And did you eventually speak with Jennifer about her intentions regarding the future of their marriage?
Not that night, no.
When did you?
It kind of changed throughout time, what her intentions were.
Okay. Can you describe to the jury what you mean by that?
So I was in the house the next day, and when Fotis arrived too. And so when I got to the house, she pulled me aside and told me that she spoke to Fotis, and he admitted to the affair, and that she was going to try and have this be as civil as possible. Because she opened up more, saying that she was no longer in love with Fotis, but she had 5 kids. So they were going to try and work out what they could.
And directing your attention now to April 2017, did Jennifer make any requests of you as to whether or not you would stay on as the nanny?
Yeah, over the next few weeks, things were changing, and so her plan changed. And she asked me to go with her when she was planning to move, and I agreed.
Where did this conversation take place?
At a coffee shop in Avon, which is the town right next to Farmington.
Were you still employed by Four Group at this time?
Yes.
Why did you decide to go with her?
Because she was my friend, and I trusted her, and I wanted to help her.
Did you ever talk to Mr. Dulos about your future with Four Group?
Yeah, at that time, I've been working for Four Group for a few years, and I just had no interest in it at all. And so I didn't see a future with Four Group anymore.
Did you give your notice?
I did. It was going to be for the end of May.
I want to direct your attention now to April and May of 2017. Was Jennifer still living at 4 Jefferson Crossing?
Yes.
Was Mr. Dulos still living at 4 Jefferson Crossing?
Yes.
Were they still sleeping in the same bedroom?
No.
Where were they sleeping?
Jennifer was in their master bedroom, and they had a third floor office, but also bedroom, and so Fotis was up there.
Can you describe the dynamic between Mr. Dulos and Jennifer in April of 2017?
It started to become very tense and uncomfortable being in the presence of both of them. They were arguing a lot. It was, again, just very uncomfortable.
Were you still working for Four Group at this time?
I was.
You had mentioned that you witnessed arguments between Mr. Dulos and Jennifer.
Yes.
I want to direct your attention now to an argument that involved a piece of paper.
Mm-hmm.
Can you describe for the jury what you saw between Jennifer and Mr. Dulos and their interaction?
Objection, Your Honor. Prior bad acts, relevance as to Michelle Troconis.
Well, can you describe what you saw? We don't know what the testimony is going to be. So the jury has heard testimony that there was a lot of arguing. That's not at the level of a prior bad act. We do not know what this testimony will be. The question is, can you describe what you saw? Overruled.
You may answer the question.
So one day I drove their family car often. It was a Suburban, and I was driving through their garage. There's kind of this like little, I don't know, I guess like a bridge. There's a garage and a garage, and then you drive through. And so I was driving through and pulling into the garage. And as I was doing that in their backyard patio, I saw Fotis kind of chasing Jennifer with this piece of paper.
Objection, Your Honor.
Ground.
Same grounds, Your Honor. Prior bad acts related to Farber Dulos, relevance as to Michelle Troconis.
Well, the grounds has to be, you're stating two grounds. You're stating prior bad acts, and you're stating relevance.
Yes, Your Honor.
Overruled on relevance. Concerning prior bad acts, counsel, do you wish to be heard?
Well, Judge, I would just indicate that I can do the proffer now if the court wants, or we can do it at sidebar.
Well, prior bad acts are not admissible to prove action and conformity therewith on a particular occasion.
Absolutely. And that's, I will tell the court that that's not the offer from the state. Obviously, everything that we are about to discuss as part of the offer yesterday goes to the tension in their marriage during that time period. So that's the purpose of this offer.
Do you wish to be heard, counsel?
Your Honor, this was heard outside the presence of the jury, and this is one of the things that we discussed, and my objections based on that.
Well, of course, prior bad acts are not admissible to show bad character, criminal tendencies, or propensity, but they are admissible to show other things. And so what are you offering it to show, counsel?
Your Honor, we're offering it to show Mr. Dulos' animus, the growing tension in their marriage, and what his intent and motivation was in this particular case.
So intent and malice are grounds on which prior bad acts can be admitted, unless the probative value is outweighed by the danger of unfair prejudice. What is your argument, counsel, on unfair prejudice?
Your Honor, these incidents that are going to be described and that are being described right now involve a very short period of time in 2017. The incident for which we are here today is one that is alleged to have occurred in 2019. The incidents that are being discussed here today involve marital discord involving yelling and disagreements in the context of an impending dissolution of marriage. The charges for which are being brought today involve a conspiracy murder.
So, in other words, your argument, counsel, it appears to the court is that these incidents are too remote in time to essentially give life to intent and malice.
And not similar in nature, Your Honor.
Well, at this point, the testimony is that Fotis was chasing around Jennifer with a piece of paper. So the description of that act as a prior bad act is not evident to the court. Cross-examination is available on what chasing around means. So it's overruled.
Thank you.
I don't remember the exact question, but we were discussing an incident that you observed between Mr. Dulos and Jennifer involving a piece of paper.
Mm-hmm.
Can you just describe for the jury what you saw?
So after I pulled into the garage, they saw me pull in and they both went inside. And so I had some of the kids in the car. I don't remember where we were coming back from, but we walked in through the garage to the mudroom, to the kitchen. And I just kind of like focused on the kids, getting them to where they needed to be. And it was later on that Jennifer told me what Fotis was saying.
Well, it was later on that Jennifer, and then the court did not hear the balance of the
Told me, Your Honor.
testimony. So if the objection is, well, first the objection has to be timely. If it's not timely, you have to move to strike.
So,
Your Honor, I heard Jennifer told me. It's a hearsay objection.
so if I may,
No,
Judge,
you object to the question, not the response. You can have the response stricken. What's the question, counsel?
well, the question was for her to just describe what she had seen. I'm not claiming what counsel's objecting to, so perhaps I could just ask another question. We can move this objection out.
Like, so the last sentence, Jennifer told me, that's non-responsive to the question. So if the objection is essentially, it moves into an area that's not responsive, the court will strike that answer.
Thank you, Your Honor.
Don't tell me what Jennifer said to you about the interaction. I want
Okay.
you, though, to describe Jennifer's demeanor as you saw her being chased with a piece of paper.
She looked scared and worried.
And can you describe Mr. Dulos' demeanor for the jury during that same interaction?
He looked angry.
Did you ever witness Mr. Dulos make any threats about the children?
Yeah.
And did he make these threats in Jennifer's presence?
Yes.
What type of threat did he make to Jennifer?
That he would take the kids to Greece and not come back.
And did Jennifer ever express her fear to you that that would happen?
Yeah, a lot.
When was this threat made?
Through those couple months, so April, May 2017.
Did there come a time when Jennifer made a decision to leave 4 Jefferson Crossing?
Yes.
Did she ask for your help in doing so?
Yes.
Can you describe for the jury what you did for Jennifer?
We were slowly moving things out of her 4 Jefferson house to a property that her parents owned in Pound Ridge, New York, and to a friend's house in Farmington. Things that Fotis wouldn't really notice being gone.
Did she tell you why she believed she needed to secretly move out of the house?
Yes.
Oh, did she tell you? In other words, it calls for what Jennifer told her. The answer is yes or no. It's the next question that may run into the objection.
Did she tell you why she believed she needed to secretly move out of the house?
Yes.
Objection, Your Honor.
Because the question is probably, what did she tell you? Objection is hearsay. Counsel.
Yes, Your Honor. This is a statement of an existing belief under 8.3 subsection 4, and I do claim this.
Well, a statement of belief is not the same as a statement of then existing mental or emotional condition.
If I could be more specific, Your Honor, it's a statement of fear, which I think undoubtedly meets the hearsay exception.
So if the testimony is she was afraid, if that's the testimony, what's your response? Afraid of Fotis Dulos. What's your response?
Speculation, Your Honor.
The objection's overruled.
What did she tell you about why she felt she needed to secretly move out of the house?
Because she was afraid of what Fotis would do to her or with the kids if she filed for divorce while they were living under the same roof.
During this time period where Jennifer was moving out of the home secretly, can you describe her emotional state for the jury?
At first, she was really calm. So when she first found out about the affair, she was calm and she really wanted to try and make it work, which I thought was really good of her because I wouldn't have been that calm. But she was very calm. But then over the weeks from after we got back from that spring break until we left in June, she was increasingly getting more afraid. Like her anxiety was really bad. You could tell that she lost weight. Like she was just afraid and expressed that a lot.
And did there actually come a point in time when Jennifer was involved in a car accident?
Yes.
How did you become aware of the car accident?
Jennifer called me because she was in Pound Ridge where she was bringing stuff to the house that she was moving from Fort Jefferson. And she called me to tell me about the accident because she needed someone to come pick her up. And she didn't want Fotis to know because she didn't want Fotis to know that she was moving things into another house.
Describe her demeanor when you picked her up.
Like terrified, like shaking, like he's going to find out. She was really worried.
I want to direct your attention now to May 2017. Did there come a point in time when Mr. Dulos had family members visit Fort Jefferson Crossing?
Yes.
Who visited Fort Jefferson Crossing?
It was his niece, Clea, and her, I don't know if it was her boyfriend or fiance at the time, Nacho.
And where were they from?
They were living in Madrid.
You said Madrid?
I believe, yeah, it was Spain, I think.
And while they were visiting, did you witness another argument between Mr. Dulos and Jennifer?
Yes.
Can you describe to the jury what happened?
Yeah. I was in one of the kids'
You're
rooms.
under same grounds.
Oh, can you describe what happened Not a hearsay objection, overruled.
So I was in one of the kids' rooms and we were just doing a puzzle together where all of a sudden, like, we started to hear screaming and Jennifer ran through the bedroom door. I don't believe that she knew that we were in there, but she ran through the door. Fotis was yelling. I'm not sure what he was yelling. And she closed the door behind her and pushed her body up against the door. And he was trying to get in. And her face was just, she was terrified. And she saw that myself and her daughter were there. And to be honest, I kind of froze because I didn't know what to do. And then when he pushed the door more, he saw that his daughter and myself were in there. And his demeanor totally changed. He went from yelling to like, Jennifer, I just want to talk, like very soft spoken. It was so weird. And so eventually he walked away because myself and her daughter were there. She told me she needed to get out of the house. And so she left me with the kids and she just got in the car and I think she just went down the street to really just like kind of catch her breath.
What we'll do at this point, because we started late with the jury, we will take our morning recess and come back in at 11:40. Please do not discuss the case.
All rise. This Honorable Superior Court now stands in recess. You may exit the courtroom. Court is in recess.
Your Honor, I'd like to be heard before the jury comes in.
Yes.
Your Honor, yesterday we had a hearing on a motion in limine, and it involved all of these alleged prior bad acts. And we had made arguments on it, and Your Honor had determined that we would address them as they came in. The purpose of having the hearing on the motion in limine is so that it did not need to be litigated in front of a jury each time one of these acts were proposed to be admitted and heard before the jury. I would move to strike the testimony that came in regarding the prior bad acts that came in already. I'd like to be heard about the fact that the ones that have come in are remote in time, do not go to intent, and if Your Honor has found that they are not too remote in time, and they do in fact go to intent 2 years later, that they are not relevant as to Michelle Troconis based on any evidence that's come in up till now. Your Honor, if you are inclined to continue to allow this, I would ask at the end of direct that you give the court a limiting instruction.
Thank you. What the court is not inclined to do is call the game before pitches are thrown. The court is not inclined to give a limiting instruction at this point because the pitches haven't been thrown. Motion is denied. Bring the jury in, please. Counsel stipulate?
Yes, Judge.
Yes, Your Honor.
Thank you. The witness can be brought back in.
Yes, Judge. And just before we begin, I did indicate to the court at the break, I had transposed exhibits 14 and 15. 15 was actually 14 and 14 was 15. I apologize. I just wanted to make the members aware of that.
Thank you.
Good morning again.
Morning.
May I proceed, Your Honor?
Yes.
Ms. Almeida, you had indicated that you had driven the family's Chevy Suburban. Is that right?
Yes.
How many vehicles did the Dulos family have in the spring of 2017?
So they had the Chevy Suburban. Fotis had a Porsche Cayenne. Jennifer had a Range Rover. And they had a Jeep, but I don't know if that was it was a Florida car. I don't know if it came to Farmington yet or not at that time.
I want to direct your attention now to the Porsche Cayenne, if I could. First of all, what type of vehicle is that?
It's like a small SUV, I guess.
And did you ever witness an argument between Jennifer and Mr. Dulos over the Porsche Cayenne?
Yes.
Can you describe that argument for the jury?
Yep.
Objection, Your Honor.
Well, the question is, can you describe the argument over the Porsche Cayenne? What's the relevance, counsel?
So the relevance, Your Honor, is that once again, this goes to the antagonistic relationship that was developing between Mr. Dulos and Jennifer Dulos during those spring months of 2017, and specifically that this particular incident involved the Dulos children and the fact that Jennifer became greatly upset based on something that Mr. Dulos was doing.
Well, if this is testimony about what happened in 2017, every incident that occurred during the course of a strained marriage is cumulative. So at this point, the court is going to sustain the objection.
I want to direct your attention now to June 19th, 2017. Can you tell the jury what happened that day?
That was the day that Jennifer planned for us to leave Fort Jefferson.
When you say Jennifer planned for us to leave Fort Jefferson, who are you referring to?
The 5 kids, Jennifer, and I was helping her along.
Was Mr. Dulos aware that you were going to be leaving Fort Jefferson?
No.
What was the plan to leave Fort Jefferson without Mr. Dulos becoming aware?
The plan was she told him that we were all going to be visiting her father's grave, and we were going to New York. We went to New York often because that's where Jennifer's parents were. And we left like that afternoon, I believe. And we just got in the car, and the plan was to stay at a hotel that we've never stayed in before. So we stayed at the Mandarin Oriental in the city. And Jennifer hired an armed bodyguard to be outside of her room because she was afraid, because her plan was to file for divorce once we were in the city in the hotel.
Did you ever hear from Mr. Dulos on June 19, 2017?
Yes.
How did you hear from him?
He called me a bunch that evening.
Did you ever answer the phone?
No, I didn't.
Did he leave any voicemails?
Yes.
What did he say on the voicemail?
He accused me of kidnapping their kids, and that he was going to call the police, which he did.
And how long did you stay at the hotel?
I stayed for like half a week, but they stayed for a full week.
Where did Jennifer end up residing after leaving Fort Jefferson Crossing?
She rented a home in New Canaan, Connecticut.
What was the address, if you recall?
153 Chichester Road, I believe.
So not 69 Wells Lane initially?
No.
Directing your attention now to approximately 8 days later, was there a family case pending between Mr. Dulos and Jennifer at that point?
Yeah.
And did you testify in the family case?
Yes, I did.
Was that in this building?
Yes.
Did you see Mr. Dulos in this building prior to testifying?
Yes, outside in the hallway.
Was he with anyone?
He was with his lawyers.
Did he approach you?
Yes.
Can you describe his demeanor as he approached you?
He came at me, yelling at me, again accusing me of kidnapping his kids. And then I just walked away. And then he tried to approach me later with his lawyer in a different demeanor, just apologizing, saying that he's just really upset. But I just walked away.
And did you testify on Jennifer's behalf in the custody case?
Yes.
Going forward from June 27th, 2019, did you continue to work as a nanny for Jennifer?
Yes.
Well, counsel, you said June 27th, 2019.
Sorry, strike that. Let me rephrase the question. June 27th, 2017, did you continue to work as a nanny for Jennifer?
Yes.
And were you still working for Ford Group?
No.
Did your responsibilities change with the kids, given the new location?
Yes, I think I became more, it was only myself and Jennifer. So there was no other babysitters or anything, other than she met some people in her time in New Canaan, so there'd be a babysitter on a day I couldn't go, or she needed an extra hand, but it was mostly just Jennifer and I, so my responsibilities became more.
And were you ever tasked with the responsibility of dropping the children off at 4 Jefferson Crossing for visitation with Mr. Dulos?
Yes, I was in the beginning.
Approximately for how long were you tasked with that responsibility?
Just a few times, and I told Jennifer that I no longer wanted to do it.
I want to direct your attention now to September 20th, 2017. Did you drop the children off at 4 Jefferson Crossing that day?
Yes.
Did you see Mr. Dulos on that day?
Yes.
Did Mr. Dulos approach you on that day?
Yes.
Can you describe his demeanor when he approached you?
He was angry and yelled at me, and again is accusing me of kidnapping his kids and telling me that the only reason why I was there for Jennifer was because she paid off my student loan, which is an absolute lie, and that he was going to make sure that I never see his kids again, but yelling in front of the kids. So it was very uncomfortable.
Did you ever do a drop-off with the children again?
After that time, no. I told her I no longer wanted to be around him.
Did Jennifer and Mr. Dulos ever officially finalize their divorce?
No, they did not.
Was their divorce ongoing in May of 2019?
Yes.
In May of 2019, how often was Mr. Dulos permitted to see his children?
He had supervised visitations, so he had to have someone from the court along with his visitations, which was every Wednesday for a few hours. And with that visitation, it needed to be agreed upon with the supervisor and Jennifer through something I believe was called the Family Wizard, for them to communicate, because they no longer could communicate through text or through phone. Everything needed to be recorded. So it was supervised visitations once a week.
I want to direct your attention now to the week of May 20th, 2019.
Mm-hmm.
Were you working as a nanny for Jennifer during that week?
Yes.
And I want to begin with May 21st, Tuesday, 2019.
Okay.
Where were Jennifer and the children living at that point?
So they now have moved to 69 Wells Lane in New Canaan.
Did Jennifer own that home?
No, she was renting.
In addition to yourself as the nanny, were there any other individuals who were frequently in the home besides the family itself?
There was a cleaning person that would come often. Her name was Edie. I don't know if it was like once or twice a week.
And how often were you working for Jennifer in May of 2019?
So the weekends were less, but it was usually Monday through Thursday and Sunday most of the time. But I would always have Friday and Saturdays off.
Had you had any contact with Mr. Dulos from September 2017 until May of 2019?
He was emailing me back and forth.
But other than that?
Other than that, no contact.
How did you typically get into the house at 69 Wells Lane?
So they had a 3-car garage, and I would enter through the middle because they had a keypad, and that's what the keypad would open. And I would enter through the garage, and then there was a door that led to the mudroom, and that's how I would get in the house.
What types of vehicles did Jennifer own?
So she had a Suburban, and she had a Range Rover.
Where would she typically keep the Suburban and the Range Rover?
So the Suburban was on the left side of the garage, and in the middle was the Range Rover. And then the third and last bay we had a bunch of shelves for sporting equipment and the garbage can, so that was typically left open.
Are you familiar with something known as WeatherTech lining?
I think that's like a Suburban or line your cars with. Maybe not. I don't know.
Maybe
I think
somebody-
yes.
Well, let me ask it this way. Did Jennifer have lining in her Suburban?
Yes.
Where was the lining?
It was in the car, so it was like the mats and then the trunk because the kids would throw their sports stuff in there all the time. So it was like, I think, a way to protect the car.
And had you actually seen the lining in the trunk of the Suburban?
Yeah, it never came out of the car unless she brought it to a car wash and they took it out to clean it, but they always put it back in.
What type of material was this made out of?
Like rubber.
When you would enter through the garage, you indicated that you accessed a mudroom. Is that correct?
Yes.
Was the door to the mudroom ever locked?
No, that was kept open.
When would it be locked?
The door leading into the garage,
Yes.
that door was never really kept locked. It was kind of just open.
Now, I want to direct your attention to that day, Tuesday, May 21st, 2019. Was there a basketball hoop being installed at the residence?
Yeah, so the boys got a basketball hoop as a gift from their grandmother. So they were getting it installed in their driveway. It was one that you had to dig a hole for and put it in that way.
And did you, were you present when that was taking place, the basketball hoop being built?
No, I showed up after. So it happened earlier that morning.
Did you have a conversation with Jennifer about the garage that day?
Yeah, so she went to show me the basketball hoop because she was like really proud of it. So we were on our way outside and just in passing, she's like, this is a mess.
Objection, Your Honor, hearsay.
So the hearsay came in at the end of the question. What is the question?
Whether or not she'd had a conversation with Jennifer about the garage?
So the answer was yes. And then the response was, she said, hearsay.
Well, my response, Your Honor, is that I'm not offering this for the truth of the matter asserted, and so I'm not offering it for a hearsay purpose. It's meant to explain why this witness took subsequent action in the garage.
The counsel approach, please.
You may ask me questions.
What did Jennifer say about the garage?
She said the garage was a mess and that was it. So I decided to clean it that day.
What area of the garage did you clean?
I cleaned that third open bay that had all their sports equipment in it.
And how did you clean the area?
I guess it was just more like organizing the shelves and organizing what was on the floor and just putting things in certain spots.
Were there any cleaning supplies in the garage?
Yeah, there was a bucket of cleaning supplies.
What color was the bucket?
To be honest, I don't remember. I believe it to be white or red.
Can you describe the bucket for the jury? I mean, is it one of these 5-gallon buckets or?
Yeah, it was one, like, I guess it's 5-gallon. I don't know. But it would just have things like Windex and cleaning solutions, sponges, things like that, that the cleaner would use, like grab on into when she would enter the house to clean the rest of the house.
And while you were cleaning the garage, did you notice any camping pillows?
Yeah, so the kids would go on a day-night trip with their school where they had to bring camping supplies, like a camping pillow and sleeping bag. So I kind of put that in the corner. That it just kind of lived in the garage.
So the camping pillows were in the garage?
Yes.
I want to direct your attention now to the next day, Wednesday, May 22nd, 2019. Were you working that day?
Yes.
And what time did you arrive at work?
I usually arrive around 12-ish. It depends. Sometimes I come in earlier.
Do you remember what you did upon your arrival at work that day?
On Wednesday? Well, Jennifer, there was a visitation that day, so I usually go to the house first and kind of like pick up after the kids or their rooms and stuff. So probably like made the beds.
And you mentioned that there was a visitation that day. Who had visitation?
Fotis had visitation.
And what time would Fotis arrive for visitation?
4:30.
And what time did he arrive on this day?
This day he arrived at 4.
Was this unusual?
Unbelievably unusual. Fotis was notoriously late to everything, including supervised visitation.
Did you see him arrive at the house?
I didn't see him arrive at the house until Jennifer noticed him through the window because he pulled in up the driveway, and part of their agreement was that he had to wait at the bottom of the driveway for the supervisor to arrive, and then together they would drive up the driveway and get the kids for the supervised visit. So it was strange that he drove his car all the way up the driveway with nobody noticing. So Jennifer saw that he came down and got me and said, she just said, I'm going to go talk to him and see what's going on. And he said he was confused. And so he just went back down the driveway and waited for the supervisor to arrive.
Now, at some point, did you leave did you leave 69 Wells Lane?
Yeah.
Why did you leave 69 Wells Lane?
I didn't want to be around Fotis.
So what did you do?
I went into town with one of the kids. I think we grabbed lunch. I believe she had, they did horseback riding. And so we were going to that right after. So we just grabbed something to eat. And then I took her to where she needed to be.
And how long did that last where you took her out on to, what was it again?
I think it was horseback riding.
Okay.
Yeah,
How long did that last?
It's usually I believe it was like an hour and a half or so.
And at some point, did you message with Jennifer?
Yes.
And what was the purpose of messaging with Jennifer?
I wanted to make sure that Fotis left the house before I came back. So she was just letting me know if he'd left or not.
If I can have this marked, Your Honor. Judge, this has been marked by Madam Clerk as State's Exhibit 16. I did have an opportunity to show Attorney Felsen what was on State 16 yesterday. I don't know if there's any objection.
No, Your Honor.
State 16 will be admitted as a full exhibit.
So, Amanda, there is a gigantic TV behind you that we're going to turn on, and we're going to show you some things.
Okay.
Is Your Honor's TV on?
Yes.
So within State's Exhibit 16, there is a file entitled Number 1, Text with Jennifer. I'm just going to ask if my colleague can pull that up. And we're displaying page 1 of text with Jennifer at this point. Ms. Almeida, do you recognize this text message exchange?
Yeah.
Well, firstly, can you just explain to the jury what this is?
These are texts between Jennifer and I that Wednesday, going back and forth on what to do that evening of Wednesday, because I was just checking in to see if Fotis was there and how I could essentially waste time if he was still there, so I didn't have to be at the house.
And were these screenshots that were taken from your cellular phone at the time?
Yes.
And did you provide those screenshots to police?
Yes.
Okay. And many of us have iPhones, but just for the record, is this an iPhone text message exchange?
Yeah, so I was in the blue and Jennifer was in the white.
And so Jennifer writes, Fotis is still here. I know you were going to do Noel's braids. Petros is picked up by 8:30. I think he should wrap it up, ... I'll let you know when he goes. And Jennifer wrote that to you?
Yes.
And what is the message about Noel's braids and Petros being picked up? Can you explain to the jury what she meant by that?
Yeah, Noelle she had like a colony day or something at school, so she had a little outfit and she had a dress and she just wanted to wear braids. And Jennifer had many talents, but hair was not one of them. So I did her hair the night before. And Petros was at lacrosse, so it was a practice to get picked up from.
Okay. And you write, I'll just go out in gas to waste some time.
Yeah.
And then you continue, Constantine wants Dunkin'. I assume that means Dunkin' Donuts.
Yes, that does.
So maybe we do that, get gas, and then get Petros. And then she replies, okay, great, but he left so you can bring him home. Is that right?
Yep.
So she was letting you know that it was okay to return?
Yes.
Now, did there come a point in time where Fotis actually returned to 69 Wells Lane on May 22nd?
Was that Wednesday?
Yes.
Yes, actually, in between his visit or during his visit. Yes.
Okay. And were these text messages before or after he returned?
I think it was after. I'd have to look at the time, but I believe it was after.
Okay. Did there come a point in time where Mr. Dulos ate dinner on the back patio of 69 Wells Lane?
Yes.
Objection, Your Honor.
Right.
Personal knowledge.
We do not know if this witness was there, so that predicate question can be asked.
Well, let me ask it this way. Did you become aware that Mr. Dulos was going to be returning to 69 Wells Lane to have dinner?
Yes.
How did you become aware of that?
Because Jennifer talked about it.
Same objection, Your Honor.
Well,
Did you become aware that Mr. Dulos was going to go back to 69 Wells Lane to have dinner? Response, yes. How did you become aware of that? Because Jennifer told you.
I'm sorry, Mr. Cole.
Because Jennifer told her.
Yes.
And the objection is essentially hearsay. Correct?
Yes, Your Honor.
Overruled.
Jennifer told you this in person?
Yes.
And when would she have told you this in person? Was it after you had taken Noel or?
Yeah, it was when I dropped Noel off, and then by that time he had left with the kids. And so I went back to the house, and I was then taking Constantine to his lacrosse practice. So it was in between that time before I left with Constantine, or to go, to his practice.
Did you and Jennifer do anything to prepare for Mr. Dulos' visit?
Yes.
What did you do?
We locked all the doors.
Why did you lock the doors?
Because she did not want him entering the house at all. And in their living room at 69 Wells, it was all opened, windows with doors, and so you could enter. And so we made sure all of those, including the mudroom door, was all locked.
And after you assisted her in locking the doors, what did you do next?
She we were preparing the food that was going to be eaten on the patio. That way they didn't need anything coming in. So they had all the cups, utensils, napkins, plates, everything was out there on the patio.
The food as well, or that came later?
No, the food as well, because he came with the food and gave it to Jennifer. And so she had it in the fridge. So we just put it out.
Now, I want to direct your attention now to May 23rd, 2019, which is the next day.
Mm-hmm.
Did you work that day?
Yes.
What types of things did you do at work that day?
I don't remember exactly, but I'm sure the kids had practice or horseback riding or something. I usually pick the kids up from school, or I'll pick Noelle and the other 4 kids. They had different times in which they were out of school. So I would usually or Jennifer would hang out with Noelle until the other kids were picked up. And I would also cook dinner. And I did like tidying when the cleaner wasn't there. I did the tidying around the house.
So let me sharpen my question a little bit. Did you do something with paper towels?
Yes.
Okay. Can you tell the jury what you did with paper towels?
Yeah, so we buy in bulk. And so we were running out of paper towels that we keep in the pantry. And so I went down in the basement to get a 12-pack of paper towels, and I unloaded it in the pantry before I left that evening.
Where was the pantry located at 69 Wells Lane?
It was to the left of the kitchen.
And did you have any conversations with Jennifer about what she would be doing the next day?
Yes.
Were you going to be working that Friday?
Yes.
And specifically Friday, May 24th, 2019?
Yes.
Why were you going to be working that Friday if you didn't ordinarily work on Fridays?
So she asked me originally to maybe stay over on Thursday night because she had appointments in New York City to go to. She still kept her doctors here, and she had an early morning appointment on Friday. And so doing overnights was something that I would often do. It wasn't abnormal. And so the plan was for me to spend the night Thursday and then be there Friday. And I was going to take 4 of the kids and drive them up to New York to meet Jennifer at her mom's because they had an orthodontist appointment that was also located in the city.
When you say the city, you're referring to
New York City.
Manhattan.
Yeah, Manhattan.
And where did the children attend school?
New Canaan Country Day.
And you may have said this, I apologize, but what time were you supposed to be picking them up on Friday, May 24th?
So on Friday, I was picking them up like 12:15, 12:30. They had a half day that day, which they usually don't. It's usually they have half days, but it's on Wednesdays. But that day, it was on a Friday.
On May 23rd, did Jennifer tell you which vehicle she planned to take to the city the next day?
Yeah, so ultimately she decided that she was just going to spend the night Thursday, so I didn't need to sleep over. And she told me she was going to take the Range Rover because she'd only have 4 of the kids, and the Suburban is very difficult to park in Manhattan.
What time did you leave on May 23rd?
So I picked them up and we came back to the house to have Subway sandwiches that I bought them. And I think...
I'm sorry, on May 23rd.
I was May 23rd, sorry. I left my usual time, probably like around 9-ish.
Directing your attention now to Friday, May 24th, 2019. Did you receive any text messages from Jennifer's phone on the morning of May 24th?
Yeah.
I'm just going to ask that we pull. Sorry, if you can. And actually, I'm just going to. Just before we get to there, I want to just button up. Okay, can you, those are difficult to read. This is where we, I think, left off. If we can just continue on to the next page. This is page 2 of folder 1, text message from Jennifer. So this is now page 2. and directing your attention to Wednesday, May 22nd at approximately 4:59 p.m. You indicated okay to come back. She responds, yes, he'll be back about 6:15, 6:20. I'll explain. And you responded, okay. Was that in between when you took Noel and then returned to take Constantine to practice?
Yes.
Now, directing your attention to page 3, you had indicated to the jury that you had received text messages from Jennifer's phone in the morning. And I want to just direct you to the top, Friday, May 24th at 7:14 a.m. Can you just indicate to the jury what she wrote to you?
Yeah, she said, I took Instagram off so he could use it for a car ride. Petros' iPad is in my bathroom. Petros is bringing lax stick he has to bring home.
Okay. And so, first of all, just for the record, what is Instagram?
Well, it's a social media app.
Okay. And who had Instagram?
Petros had it when he was not allowed to have it because he downloaded it.
Okay. And so when she's saying I took Instagram off, she's referring to some tablet or computer that
Yes.
Petros had?
Yes.
Okay. And she's indicating he's allowed to have it now?
Yes.
Okay. And what does this mean? Petros is bringing lax sticks he has to bring home.
Yeah, so Petros played lacrosse, so he was bringing the lacrosse stick to school because I think he was playing after school.
So you received these messages in the morning. Mm-hmm. What time did you arrive at 69 Wells Lane that day?
I got there, I think it was close to 11.
And when you say 11 in the morning?
11 in the morning, yeah.
How did you get there?
I drove my car.
Did you make any stops prior to getting to 69 Wells Lane?
Yes.
Where did you stop?
I stopped at the restaurant chain Subway to get sandwiches for everybody.
And when you got to 69 Wells Lane, how did you enter the home?
Like I always do, so I typed in the code to the middle garage and went through the middle bay.
And then through the mudroom door?
Yes, and through the mudroom door.
Did you notice anything unusual when you went into the garage?
When I went into the garage, yes. The Range Rover was still there, and the Suburban was gone when she told me she would be taking the Range Rover.
Did you see any blood-like substances in the garage or on the floor?
No.
After you walked in the garage, where did you go?
So I enter through the mudroom, and I usually put my stuff. She had these cubbies, and I put my stuff in the cubby, and then I go to the kitchen. So I went in the kitchen.
When you got to the kitchen, did you notice anything unusual?
A couple things, yes.
Tell the jury what you noticed.
So first, her purse was on the floor. It was between the mudroom and the kitchen, like the doorway. It was a big, like, structured purse. And I thought it was just a little odd because it was a really nice handbag and it was on the floor. But I didn't look in the bag, so I just kind of figured she took her phone and her wallet with her to New York. And then when I entered the kitchen, she always had a tea, like in a certain cup with her, and a granola bar. She ate it every morning. It was just part of her routine, and it was there. The tea was still full, and the granola bar was still there. So I thought it was a little strange, but I just figured she was in a rush because I knew she had to get to the city. So I just cleaned the cup of tea, and I put the granola bar away.
As you were cleaning the cup of tea, did you notice the paper towel roll on the countertop near the sink?
Yeah, so the paper towel roll was empty, so I went in the pantry to go grab another one and noticed that there were only 2 rolls of paper towels left, which was odd to me because the night before I just put 12 rolls in there. But again, I thought maybe the kids spilled something and they used a lot of paper towels.
Did you do anything else when you were inside the house?
Yeah, so usually I would go in and I would go in the kids' room and like fix up their beds or put away some clothes. And then after I left to pick the kids up from school.
What time did you pick the children up from school?
I think it was around 12:30.
I'm sorry?
Like 12:30.
And where did you pick them up?
A New Canaan Country Day.
Which children did you pick up from school?
I picked up Petros, Theodore, Constantine, and Noel because Christian was going to go home on the bus with a friend and spend the afternoon there because she didn't need to go to the orthodontist.
Where did you take the children once you picked them up?
So we went back to 69 Wells and had lunch.
Did you notice any blood-like substances inside the home while you were having lunch or prior to picking up the children?
No.
Approximately how long did it take to eat lunch?
Like 20-ish minutes. We were pretty fast.
After you were finished eating lunch, what did you do?
The kids went and got their iPads for the car ride, and I just cleaned up quickly, put everything away, and then I texted Jennifer because Noelle couldn't find hers, and so I asked. We had a family iPad, and so I asked if she could take that instead. And then we got in the car and headed to New York.
Did Jennifer respond to your text message?
No,
So what did you decide to do without her having responded?
I just took the iPad. It was a long car ride.
During the car ride, did you try to communicate with Jennifer?
So right before we left the driveway, I texted her our ETA and that we would be at Gloria's. And then I just started driving. And then I texted her when we got to Gloria's.
Did you ever try to call Jennifer?
Yes, after we got to Gloria's around 2:30, and she wasn't there. And I was supposed to meet Jennifer at Gloria's. I wasn't supposed to go to the orthodontist. I was going to be heading back home, but she wasn't there. And so I called her around 4 o'clock.
And when you say Gloria, is just to refresh everyone's memory, Gloria is Jennifer's mom, is that correct?
Yes.
And she resides in Manhattan?
Yes.
And she has an apartment in Manhattan?
Yes.
And that's where you were supposed to meet Jennifer?
Yep.
Had Jennifer replied to either of your text messages
No.
prior to trying to call her?
No, none of them.
If I can just pull those up. So, beginning Friday, May 24th at 12:43 p.m. Hello, we're home and eating. Noelle can't find her iPad. Is it okay to take the iPod? Is it okay to take the iPad? And she does not respond, correct?
Yeah.
And then you texted her again, leaving now. ETA is 2:30. And she does not respond, correct?
Yes.
And at 2:30 exactly, you text, just got to Gloria's. Approximately how long after sending that text message did you try to call Jennifer?
I don't remember. I think it was close to that other text message. Will we meet you at the dentist?
Okay. And why did you send that message?
Because I hadn't heard from her. So I didn't know if I was I've been to their orthodontist. It says dentist, but it was orthodontist. I've been to the orthodontist before, so I knew where it was and I've brought them. So maybe I was going to meet there because maybe her appointments ran longer. I didn't know.
Did you go to the orthodontist with the children?
Yes, I did.
How did you get there?
We took a taxi.
Did Jennifer meet you at the orthodontist?
No, she didn't.
How were you feeling at this time?
Really bad. The second I called Jennifer, it's like my stomach just sank because she never not answered her phone. So I was really hopeful that she just got caught up with meetings and she was going to be there. And so when she wasn't there, I was shocked, but also like, okay, I have the 4 kids in front of me. I don't know what to do. So I just put them into their appointments and I I just walked outside and I started to call people that could have heard from Jennifer.
Who did you call?
Well, I called my mom, who was trying to calm me down and tell me all these things that I needed to call the hospitals because maybe she was in a car accident. And then I called her friends.
And based on those conversations, what did you do next?
Based on those conversations, I got the kids, they finished their appointment. I got them in the cab, and I had Noelle bring Jennifer's iPad, or the family iPad, but it was connected to her Google and her Apple ID. And so I decided to bring the kids back to their grandmother's. I went in the cab and I went to her appointment because I was able to pull up her Google Calendar and what appointment she had that day. So I went to one of her appointments.
And were you able to make contact with someone at the appointment, or at the location of the appointment, I should say?
Yeah, they were able to tell me. I just needed to know if she made it, and they were able to tell me that she didn't.
What did you do next?
I called her friends again, letting them know what was happening, and then I decided to take a cab back to Gloria's. And it was from there that myself and Jennifer's friend Laurel called the police.
Which police department did you call?
New Canaan.
Excuse me. And what information did you give to the police?
What information did this witness give to the police? Overrule.
Your Honor, I'd like to be heard outside the presence of the jury.
Overrule.
Excuse me, Your Honor, I apologize. You can answer the question.
We told the police that a mother of 5 was missing and that she was in a very contentious divorce. And I knew that he had purchased a gun, and so I was afraid. And they were on it right away.
I don't claim that part.
Ladies and gentlemen of the jury, the portion of the testimony that this witness knew Fotis Dulos purchased a gun is stricken. You may not consider it for any reason.
Did you ever receive any communications from Mr. Dulos that night?
Yes.
What type of communication?
He called me in the evening.
And did you answer the phone?
No,
Why not?
I was afraid.
Did you eventually speak with him?
Yes.
And can you describe that conversation for the jury?
Yeah. So he called me and I called the police because I wasn't sure what to do. And they told me that he's not a suspect, so you should talk to him because I have his kids. And so I decided just to call him back because I didn't want to anticipate waiting for the phone call. And so I spoke to him, and it was a very weird conversation. He asked how the kids were doing, but didn't talk about Jennifer or really what was going on, just saying, oh, this is really weird, and immediately went into that he had a supervised visitation that Saturday. I think because it was a Memorial Day weekend, so he had a day, it was a special thing, and that I needed to make sure that I left New York early enough that I got the kids to him to New Canaan for his supervised visit. And he was just very adamant, Lauren, you have to make sure that they're there. They need me. You need to bring them to me, be early. And then the conversation ended.
And did you also exchange text messages with Mr. Dulos that night?
Yeah.
If I could just pull them up, that's folder 2. And once again, were these screenshots from your phone that you shared with the police department?
Yes.
Okay. And you indicated to Mr. Dulos at 9:49 p.m. on May 24th, hello, no updates so far. Laurel is at the police station right now keeping me updated, but they don't have anything yet. They looked around the house, but it all seemed fine. I'm trying to get the kids to get some sleep. You sent that message, correct?
Yes.
All right. And his phone responded, okay, thank you. Please call me first thing in the morning. And then you responded, yes, I will. If I hear anything tonight, I'll let you know. Is that correct?
Yes.
And he responds, okay. Other than the phone conversation that you had with him on May 24th that you've already described for the jury, was your additional communication with Mr. Dulos done strictly through text message?
I didn't have any at that time other than that evening. I didn't talk to Fotis at all.
Well, I'm referring to these messages here that
Yeah.
we're seeing. This was after your telephone conversation with him, correct?
Yeah, it was only through text messaging.
And if we could just continue on to Friday, May 24th at 11:38 p.m., he asked you, still up, any news? And you responded, no news. They're still searching though. Got kids to sleep. Is that correct?
Yep.
Continuing on. And then, I'm sorry, could you scroll just a hair? Okay. Looks like there's part of a message that's cut off. It says, thank you. Are they okay? Are they worried? And you responded, they're doing okay. They're worried, but I'm trying to just keep them updated as much as I can to keep them at ease. I'm happy they got to bed. So presumably the children had fallen asleep at this point?
I think I was referring to the night before that they got to sleep.
Okay. And then he responds, okay, I will see you guys tomorrow. And you respond, okay, good night. Is that right?
Yeah.
So when he says see you tomorrow, he's referring to Saturday, May 25th, correct?
Yes.
Okay. And that was for his visitation?
Yes.
Were you intending on bringing the children for visitation?
No.
Why not?
I was afraid, and I wanted to keep the kids with myself and Gloria.
Now, on Saturday, May 25th at 5:39 a.m., he texts you GM, which I assume stands for good morning.
Yeah.
Lauren, any news? And you replied, called them at 2:30 and 5:30. No news. They just told me that they're still searching. And he replies, I spoke to an officer at 1 a.m. as well. Is that correct?
Yep.
And then at 10 a.m., he texts you GM Lauren, again, driving down to NC, which I assume stands for New Canaan.
Yeah.
And then he continues, spoke to Officer Patton. He had no update. How are the children? And you respond, children are doing well, just ate breakfast. And then he asks, are you guys driving to New Canaan? Is that correct?
Yes.
Did you indicate one way or the other whether or not you were driving to New Canaan?
No.
Directing your attention now to the next page. The title is Fotis New Phone. At some point, had he reached out to you from a different phone number?
Yes.
And you programmed it in as Fotis New Phone?
Yes.
Okay. And so this is him with, I guess, the initial reach out saying, Lauren, it's Fotis. How are the children doing?
Yep.
And you said kids are doing okay, getting ready to sleep. And he responds, okay, any updates? You said no, not yet. Is that right?
Yeah.
Okay. Directing your attention now to Sunday, May 26th at 10:59 a.m. Farber Dulos' new phone texts you, GM Lauren, how are the children? You respond, they're doing fine. And he asks, is Christiane with you or is she still with friends? And you replied, she's with us. Christiane was the child that you had mentioned you had a sleepover. Is that correct?
Yeah.
And how did Christiane come to be with you if she was in New Canaan?
Jennifer's friends picked her up.
And brought her to Gloria's?
Yeah.
And then he asks, okay, good, somebody brought her to you. And you replied, yes. He asks, is she okay? You respond, all are fine. She says, okay, thanks. Any update on Jennifer? You didn't respond to that message. Why not?
I just didn't want to.
Now, on Sunday, May 26th, did you see Mr. Dulos in New York?
Yes.
Where did you see him in New York?
He came to Gloria's apartment in Manhattan.
How did you see him?
Through the window. We saw his car pull up.
And were the police called?
Yes, they were.
Which department responded?
I think it was some precinct, but I don't remember.
The New York Police Department?
Yeah, it was the New York Police Department.
And did you speak with the police?
No, I didn't. Well, in the original phone call to the police?
No, I'm referring to the NYPD.
Oh, when they came to the house, I spoke to them.
Okay, in Gloria's apartment?
Yes.
And did Mr. Dulos ever see the children in your presence that day?
No.
Did there come a point in time when you were asked to review photographs of the garage at 69 Wells Lane?
Yes.
Can you tell the jury when that was?
It was, I believe it was that weekend in Gloria's apartment. The New Canaan police, they came to New York to meet with me and show me pictures.
And I'm just going to show, these were pictures that were taken by the police department? Is that right, Ms. Almeida?
Yes.
Okay. So this is, for the record, this is within State's Exhibit 16. Specifically, this is item number 3. What are we looking at here?
So this would be like where the open bay was, where all their sports stuff was. This shelf in particular was where I kept like their camping stuff and Nerf guns and stuff like that.
Okay. And you had indicated that on Tuesday, May 21st, you had cleaned the garage.
Yes.
Okay. Is there anything not visible in this photo that was visible to you on the 21st in this location?
Yeah.
Can you tell the jury what that is?
Those were the camping pillows that they had for their trips.
And where would they have been in this photograph?
They would have been next to the sleeping bags on that second shelf.
Okay. So, and just for the record, there is a shelf and there's 2 sleeping bags underneath on the second level, and they would have been next to those?
Yes.
Okay. And if we could pull up item number 4. Oh. What color were the camping pillows?
They were white.
I'm sorry, the interpreter's not here.
They were white.
So what are we looking at here in item number 4 on that disc?
So these are just more shelves in that third bay where we kept like their sports equipment and stuff.
And is there anything not visible in this exhibit that you had seen on the 21st?
Yeah, there was a cleaning bucket that I put on that third shelf, so on the bottom.
And was this the cleaning bucket that you described earlier, the red or white bucket?
Yes.
Okay. And directing your attention to the sponge in the photograph, was that on the floor when you cleaned the garage on May 21st, 2019?
No, it was in the cleaning bucket.
Now, did there come a point in time where you and the children were asked to provide DNA samples to the state police as well as fingerprints?
Yes.
Do you recall approximately when that was?
I would say it was like a week or so after we all went to New Canaan. They had an event at their school that day because they didn't go back to school. We stayed in New York this whole time. But we went to New Canaan so they could be a part of this event, and then went to the police station to give our fingerprints and DNA.
And have you continued to be the nanny for the Dulos children since May 24, 2019 to the present day?
Yes.
And I think you indicated yesterday that you still live with them?
Yep.
Are you their primary caregiver?
Gloria is their primary caregiver, their grandmother.
Have you seen Jennifer Dulos since May 23, 2019?
No.
Have you heard from Jennifer Dulos since those text messages that we saw earlier on May 24, 2019?
No.
Have a separate moment, Your Honor. I have nothing additional.
Cross-examination.
Yeah. Good morning, Ms. Almeida.
Morning.
It's actually afternoon. Good afternoon.
Good afternoon.
So you started working for the Dulos family in 2012,
Yep.
and then you started working for Four Group in 2013,
Yes.
and that was Fotis's company?
Yes.
Fotis hired you?
Yes.
And the company consisted of home construction.
Yes.
And you worked there in the mornings, either 8:30, 9 o'clock,
Yep.
until about 2 o'clock,
Yeah. Depending on when the kids came out of school.
and during the weekday.
During the weekday, yeah.
And after that, you went to work caring for the Dulos children.
Yes.
The work that you did for Fotis, for Four Group, at first was administrative work.
Yeah.
You'd go to the bank,
Yep.
sometimes run errands.
Yep.
And at some point, I think you said it came to you doing some punch lists.
Yep.
And that involved you going to people's houses where you would look at some things that were left undone
Yes.
or needed to be fixed.
Yes.
And sometimes you would be responsible for fixing them.
No, not myself.
Okay.
I would be responsible for getting the right person to fix.
Sorry. And was Pavel Gumienie one of those people who would help you fix those things?
Yeah, but it was mostly like the subcontractors. Like if it was something with the paint, the painter would need to come back in. If it was something with the roofer would need to come back.
Did Pavel ever go with you?
Yeah.
Pavel worked for Four Group.
Yeah.
Pavel was an employee of Four Group before you had gotten there in 2013,
Yeah.
and you left in 2017.
Yep.
Pavel still worked for Four Group after you left.
Yeah.
And when you weren't going to the houses to look at what needed to be done or running administrative tasks, you would work at the office.
Yes.
The office was at 4 Jefferson,
Yes.
and that's also the Dulos home.
Yeah.
So the office was in the home. Can you call up what will be marked defendants C? I believe there's no objection, Your Honor. If this can be full
I just
exhibit.
have a copy of the.
Yep. May I have a moment, please, Your Honor?
Yes.
So Judge Attorney Felsen is kind enough to show me the thumbnails of what she intends on offering. And I guess I have no objection to what she's identified for me as defense exhibits C, D, and E, and F and G. So with that.
So is the offer for all of those at this time?
Yes,
C,
Your
D, E, F, and G.
Yes, Your Honor.
So defense C, D, E, F, G admitted as full.
Can you call up what's number one on yours? And Ms. Almeida, if you could turn around, is this for Jefferson?
Yes.
And the office, can you show, do you mind getting up? Can you show the jury where the office is at 4 Jefferson?
Yeah, so the office would be this whole space up here.
Okay. All right, thank you. And can the record reflect that the witness is pointing to the right side of the image of 4 Jefferson above the garage? So it's all the way at one side. The office is all the way at one side of the house?
Yeah.
And it has its own separate entrance?
Yeah, it does. It would be underneath, like where you pull the car in.
Okay, so you can basically go in through the garage?
Yes.
All right. And Bob, can you pull up what's number 2? This is Defense Exhibit D. Can you tell the jury what that is?
Yeah, so that's the other side of the garage.
Okay.
So once you drive through, that's what you would be facing.
Okay. And did people who worked at 4 Group employees, did they in fact park in that back area that you're looking at?
Yes.
All right. And did you also park in that back area that we're looking at?
Yeah, I did.
All right. Bob, can you pull up number 3, which is Defense Exhibit E? And this view, can you tell the jury, is this in fact looking from the vantage point at where the 4 Group employees would park in the back of 4 Jefferson?
Yep. Yeah, that was right behind the house. There was a little stone area where you would pull up to park.
Okay. And Bob, can you pull up 4, which is Defense Exhibit F? And do you recognize this picture?
Yeah.
Is it one of the rooms of 4 Group, one of the office rooms?
Yeah.
All right, and that's above the garage?
Yep.
With its own separate entrance. And did you work in this office?
Yes, I did.
Did you actually work at this table or something similar to it at the time back in 2013?
Yeah, I usually sat at that table, and there was a table on this side that I would sometimes sit as well.
And other employees worked there as well?
Yeah.
About 4 or 5, you said?
Yeah.
Was Mr. Dulos, Fotis Dulos, was sometimes there at the office with you?
Oh, yeah.
All right. And he sat at that desk with you?
Yep.
And you worked with him side by side?
Yep.
And you saw him almost daily?
Yeah.
And you had an opportunity to observe him with other employees?
Yes.
Bob, can you call up number 5? Showing you Defense Exhibit G. Is this another room upstairs in 4 Group's office?
Yeah, so this is past the room that you just showed.
Okay. And would you also work in this room?
Not usually, because usually that's the room where, like, if he had clients come in, he would use the table there to sit with people and go over things.
So clients would meet at the 4 Group office?
Yeah.
And people would come in and out of the office?
Yeah.
Pretty regularly?
Yeah.
And they would enter through the garage?
So it wasn't like inside the garage. You could get to the office that way, but there was an outside door that you could get. There was a stairwell.
That's separate from the
house. Yes.
Right? People would just go to the office, but wouldn't necessarily walk through the house.
Yeah. Yeah.
So people could be there in and out all during the day, but wouldn't at all interact with the people who were inside the home.
Yeah.
You can take that down. Thank you. You talked about some other people who had worked at 4, and you said that Pavel was one of them, and he helped you sometimes.
Yeah.
And there were other people who worked there when you were there from between 2013 to 2017? Mm-hmm. May I have one moment, please, Your Honor? Your Honor, I'd ask that Defense Exhibit H be moved in as an exhibit. I don't believe there's any objection.
That's correct, Judge.
The defense H will be admitted at court.
Bob, can you call up number 6? Ms. Almeida, do you recognize some of the people in this photo?
Yeah.
All right. And on the bottom left, is that a photo of Pavel Gamianian?
Yes.
And he was the worker we just talked about who worked at Ford Group from before you started in
Yeah.
2013, who remained at Ford Group working with Fotis.
Yes.
He worked for Fotis?
Yeah, I think at first he was a subcontractor, and then eventually moved us to employee.
Okay. Did he become a project manager?
Yeah.
All right. And he worked closely with Fotis from what you could observe.
Yeah.
And he interacted with him daily?
Yeah.
All right. How about next, obviously the top left, is that a picture of Fotis Dulos?
Yes.
All right, and you recognize him?
Yeah.
All right, and that's how he appeared to you at times between 2013 and 2017?
Yeah.
And next to Fotis Dulos is Guillaume, is it Vitale?
I think.
I'm not sure. Are you familiar with him?
Yeah.
All right, did he work at Ford Group at the time that you worked there?
Yeah.
And between 2013 to 2017, was he there during that entire period of time?
Yes.
All right. How about Stefan Reich?
Right. Yeah.
Reich. He worked at Ford Group.
Yes.
What did Mr. Reich do at Ford Group? When
He was
working?
real estate, so he was an agent. So.
Did
showing
he
places.
work with Ford Group from 2013 through 2017, to your knowledge?
No, I think he left the company when I was there, but I don't recall when.
Okay.
But I think that they still maybe consulted with each other.
You think they kept in touch
I think so, yeah.
from a business point of view?
Yeah.
Okay. And how about Matt Byrne?
Yeah.
When to when did Matt Byrne work for Ford Group?
So Matt came in after me, but I don't remember the times.
Okay. Was he there when you left in 2017? Was he still working for Ford Group?
I think so.
How about on the bottom right, that Ben Corbett? Did he work for Ford Group?
He did.
All right. And did he work for Ford Group in 2013 when you were working there?
Yeah, but he was younger. He was still in college. So he's finishing college and he would come back for like summers and breaks and he was helping not so much like project managing, but like tasks around the company or things like that. Okay. And then I think when he graduated, Fotis offered him a position.
And do you know whether he took it?
He did, yeah.
Okay. And did he also help around with the kids?
Ben, yeah.
All right. Did he also go on vacations?
Yes.
All right. How about Mr. Vitale? Did he also go on vacations with the family ever?
Yeah.
All right. So you can take that down. Thank you. Mr. Dulos had a good relationship with most of his employees, it sounds like.
Yeah.
And he was close with them?
Some of them, yeah.
And spoke to them pretty regularly?
Yeah.
And socialized with them?
Yeah.
For a time, you had a good relationship with him.
I did.
You considered him a mentor?
I did.
All right. So when you left working for Ford Group at the end of your workday, you went and cared for the Dulos children.
Yes.
And while doing that, in that capacity, you had an opportunity to observe Fotis Dulos's and Jennifer Dulos's relationship.
Yes.
And you were able to observe it from when you started in 2012?
Yep.
And you always thought that the dynamic between Fotis and Jennifer was odd.
Yeah.
early on in your employment.
Yeah.
From 2012.
Yeah.
And it wasn't a typical relationship.
I mean, I'm going based on what I grew up with. So to me, no, it wasn't.
Not like anything you've seen before or dealt with before.
Yeah.
In your experience.
In my experience, yeah.
And early on, we're talking 2012, 2013, he took a lot of vacations.
Early on and throughout.
Early on and throughout.
Yeah.
He took vacations with the family.
Yep.
And he took vacations with you as well as the family.
Yep.
And then he took vacations with just you and the kids.
Yep.
Did he ever take vacations with just the kids?
The two older boys.
Okay. And he also went away quite a bit on his own.
Yes.
From early on.
Yes.
And you didn't know where he was going.
No, early on, no, I have no idea.
You didn't know if it was for business.
Nope.
You didn't know if it was a vacation.
Nope.
You didn't know if it was a ski competition.
No, I didn't know.
And you didn't know if he went with anybody.
Early on, no.
And you didn't know if he met anybody when he was on vacation.
No.
All right. And you don't know where he went.
No.
And as part of your observation of their relationship, Jennifer seemed to be totally fine with that.
Yeah, it didn't seem to like bother her so much. And again, I was coming from what I believed. He was away a lot. If that was me, I would probably be like, why are you away a lot? But at that time, again, I was just starting and I was there just once a week and I wasn't as close with them as I became to be.
Understood. And you said you went on vacations with the Dulos family.
Yep.
And sometimes you traveled with Fotis alone.
Yep.
Did you go with Fotis, not alone, but alone
With
and
the kids. Yeah, with the kids.
Did you go with Fotis alone and with the kids to Greece?
I did.
All right. And did Fotis introduce you to some women friends of his in Greece?
Yes.
And did you ever go alone with Fotis to Miami?
Yes.
And was that prior to or after March of 2017?
Well, so it was March 2017 was the first time that I was like alone with him and the kids. He would take trips with the two older boys to Miami just by himself.
But March 2017 was the first time you went with Fotis and the kids to the Miami Ski Club?
Yeah.
And you went several times that week that you were there to the Miami Ski Club?
Yeah.
That's a private club?
Yeah.
Members only?
Yeah.
Do you know if Fotis was a member?
He was.
You said he had a boat?
Yeah.
And all the times that you went with Fotis, the kids also went?
Yeah, I was always with the kids.
But Jennifer never went?
Jennifer never went.
It's about 1 o'clock, Jenny Felsen. We can pick up the direct cross-examination after the lunch and recess. We'll take the lunch and recess, ladies and gentlemen, until 2 o'clock. Please do not discuss the case.
Thank you, Your Honor.
All rise. This Honorable Superior Court now stands in recess until 2. Please. Honorable Judge Randolph presiding. Good afternoon, Your Honor. It is?
Not ready.
Okay. You could We're now opening back in session. Good afternoon, Your Honor.
Good afternoon. Please be seated. Thank you. Well, we are not bringing a jury in right now.
Your Honor, if I may, just
Yes.
put something on the record.
Yes.
If I can, Your Honor. When I was en route, myself and Attorney Moran, who is sitting with us from our office assisting in this case, we're en route upstairs. We were on the elevator banks as one of the marshals was bringing two of the alternate jurors back upstairs. When the elevator doors opened, Attorney Moran and myself, when we realized who was inside the elevator, we turned around and immediately walked away. We did not say anything. And the marshal escorting the jurors leaned out and said, "Thanks, Liz, we love you." And the elevator doors closed. So at that point, I immediately came upstairs and informed Attorney Felsen and Attorney Schohorn, as well as the marshal's service. And I'm bringing that on the record now that that exchange happened. No one from the state said anything back. In fact, we walked away quickly when we realized who was in the elevator bank.
Attorney Felsen.
We had some
Attorney Schoenhorn.
discussion about that. I don't think we need to put a lot on the record. I think it was inadvertent. I understand that the marshals are just going to switch. And I think that the only thing that maybe the court should do is at least advise the jury that any comments they hear in the hallway or the elevators about anybody connected to the case should be disregarded. And I think that that probably would take care of it. I'm not seeking anything more important than that. I'm certain it was inadvertent.
Thank you. First, the court will address the supervising marshal in the courtroom. No marshal is to comment at any time on the case or any individuals involved in the case, or comment on the court, and no marshal is to have any conversation with individuals, specifically counsel and the staff of the State's Attorney's Office, or the staff or counsel for the defense in the presence of any juror. Now, what has happened today is the court agrees with Attorney Schoenhorn, inadvertent. Attorney Moran is not conducting any cross-examination or direct examination. She is assisting counsel in the presentation of the exhibits. The court is not convinced that the comment from the marshal will lead the jury to, or those jurors who heard it, to opine about the nature of the state's case or the nature of the defense. If the comments had concerned perhaps Attorney McGinnis or Attorney Manning and had been of the tenor, "We love you, you're doing a great job, keep it up," that's a different story. But as of right now, the court thinks any opinion formed by alternate jurors based on the comment to Attorney Moran is of little effect. But the court will address the jury when they come in.
There is one other matter, Judge, that I need to raise at this time, and I'm doing it at the earliest moment before the jury comes in. One of the reasons we file our motions in limine is so that issues that are potentially prejudicial and require some deliberation on the court are heard in advance outside the jury's presence. So when the current witness, Ms. Almeida, was on the stand, we were aware of, we had listened to the 911 calls. We were aware of the highly prejudicial nature of some of her comments that were clearly hearsay. And I note specifically that we were aware, and the state was aware of our concern about the issue of a mention that at some point Mr. Dulos had purchased a firearm that he then disposed of years ago as part of a divorce case. So when that was said, Your Honor, we tried, Attorney Felsen tried to get this decided so that the witness would be admonished outside the presence of the jury. There are cases such as State versus Onofrio in 179 Connecticut, State versus Girolamo, Girolamo in 197 Connecticut, State versus Williams in 182 Connecticut, where those cases say that evidence about guns, where that is where firearms is not a part of the case, is particularly inflammatory and can have an effect on the jury's judgment. It awakens sympathy, passions, and influences the judgment of the jury and cannot be considered harmless. Based on that, Your Honor, and I'm reluctant to do this, but I'm making a motion for a mistrial.
The motion's denied. The court received a motion in limine this morning. If the defense had indicated in the motion in limine exactly what this witness may say that was prejudicial concerning guns or the purchase of guns, it should have appeared in the motion. That would have alerted the court to the nature of the hearsay. But a general motion in limine to preclude hearsay is not enough for this court to grant a blanket motion without having some roadmap as to what the highly prejudicial nature of the testimony would be.
Your Honor, it had to do with the motion yesterday regarding marital discord. That was where the court would not entertain a proffer about what issues would or would not be allowed in and would hear them as they arose. And that's what I'm referring to more so than the fact that this witness was allowed to testify about her conversations to the police, which is also, I note, testimonial in nature.
Well, a general motion in limine about marital discord does not lead to this court considering testimony about a gun. And so motion for marital discord generally may involve contention, arguments, physical assaults, but not the purchase of a gun. So the court is not on notice from a motion to preclude testimony about marital discord that there may be evidence of a gun. And again, the motion in limine filed today mentions nothing about a firearm or a purchase of a firearm. So the court has no idea as to what the prejudicial, unfairly prejudicial nature of the testimony would be. You can bring the jury in.
Sure.
Would counsel stipulate to the presence of all of the jurors?
Yes, Judge. Yes.
Ladies and gentlemen, it was brought to the court's attention that there may have been a number of you, perhaps the court should say a few of the alternate jurors, who may have overheard a comment from one of the marshals who have been assigned to this case. And that comment was directed towards Attorney Moran, who is sitting behind counsel table, sitting behind attorneys Manning and McGinnis. And that comment was directed towards her, but it was probably overheard by one or more of the alternate jurors. And that comment was essentially a complimentary comment to Attorney Moran. It was brought to the court's attention that that comment may in some way be perceived as an opinion by one of the marshals as to the strength of the state's case. The court is not convinced that that comment was an endorsement of the strength of the state's case. Nevertheless, what the court will do is indicate to you that if you hear any comment from any of the court staff concerning any other participant in the trial, or the nature of the state's case, or the nature of the defense case, first, if you overhear it and you think it needs to be brought to the attention of the court, it should be brought to the attention of the court. Secondly, if you think it probably means very little or has little effect, just ignore it. However, any comment that would suggest that the strength of the state's case or the strength of the defense case is being articulated in your hearing, that should be brought to the attention of the court. Thank you. We can bring the witness back in. You may proceed, Counsel.
Thank you, Your Honor. Good afternoon again. Hi. We were talking about the Miami Ski Club, I think, when we were last here. The Miami Ski Club is a water ski club.
Yeah.
And it's members only,
Yes.
private.
Yes.
And Fotis had a membership there.
Yes.
Do you know for how long Fotis had that membership?
I'm not exactly sure.
But Fotis had been traveling down to Miami for some time,
Yes.
alone
Yes.
and with the kids,
Yes.
for years.
Yeah.
And Fotis water skied
Yes.
competitively.
Yes.
You describe him as very competitive,
Yes.
and not just in water skiing,
With everything.
everything. Had he been water skiing since when you first met him?
Yeah.
And he taught the kids to water ski?
Yeah.
And they all water skied?
They all water ski. Yeah.
Some of them competitively?
Yes.
They had won medals?
Yes.
Did he teach you to water ski too?
He did.
All right. And I think he also taught you how to drive the boat?
Yep.
When you went to the Miami Ski Club in March of 2017, and you met Michelle
Yes.
for the first time,
Yes.
and you met her daughter as well. Her daughter was there.
Yes.
Your Honor, I'd move into evidence. Defendants. I changed the numbers a little bit. It's I-1 through I-4, I believe, without the state's objection.
That's correct, Judge.
The defendants I-1 through 4 admitted as full exhibits.
And can you pull up Bob I-4, please? Thank you. Ms. Almeida, do you recognize some of the people in this picture?
Yes.
Is Fotis in this picture?
Yes.
Is Michelle in this picture?
Yes.
And the Dulos children?
Not all of them.
Okay, but some of the Dulos children are in the picture?
It looks like 2 of them.
Okay. And do you recognize Michelle's daughter in that picture?
Yes.
All right. And is that at the Miami Ski Club?
I think so. It's kind of hard to tell.
Do you remember if you took the picture or not?
No, I don't remember.
Okay. But you had been at the Miami Ski Club before?
Yes.
All right. And you recognize Fotis and Michelle in this picture?
Yes.
All right. And at least 2 of the Dulos children and Michelle's daughter?
Yes.
All right. Thank you. Thank you. Was Michelle at the ski club every time that you were there when you went there in March of 2017?
No, I don't think so.
All right. How many times did you go there that week?
To be honest, I don't really remember.
But you went frequently?
Yeah, the reason for that trip was so that they could water ski.
Okay, so I'm assuming you went every day.
Yeah, we probably went mostly every day.
All right. And you were there for lengthy periods of time?
Yeah.
And Michelle was there several of the times at least?
Yeah.
All right. And she was interacting with Fotis?
Yep.
And the kids?
Yeah.
And they seemed familiar with her?
Some of the kids.
All right. And you observed that? It was in front of you?
Yes.
It wasn't being done in private or in secret?
No.
And I think you mentioned you spoke to Michelle?
Yep.
And she told you that she intended to move to Vail, Colorado with her daughter?
Yes.
Do you know, in fact, whether she did that at any point in time?
I don't know.
Did Fotis water ski a lot?
Yes.
All right. Did you go with him sometimes down to the pond?
With the kids, yes.
Okay. There was a pond in Avon, Connecticut?
Yeah, in Avon.
All right. And he would go down there?
Yep.
All right. And would you ever go with him when he competed?
Yes.
All right. And would the kids go with him and with you when he competed?
Anytime I went with Fotis, it was always with the kids to watch him compete or the kids compete.
Okay. Bob, can you pull up I-1? Do you recognize the people in this picture?
Yes.
All right. And is that Fotis?
Yes.
And is he with one of his children?
Yes.
Was this picture, you did not take this picture, did you?
No, but I know where that picture was taken.
All right. Do you know, can you tell the jury when this picture was taken?
Yeah, so we were coming back from a trip, a ski trip. It was around Christmas time, and some of us got on a plane. There was a lot of cancellations and stuff like that, and I wanted to be home for Christmas, so Jennifer, myself, and 4 of the kids were able to get on a different flight because ours got canceled to be back home, and there was only enough seats for all the amount of that was there. And so there were Fotis and Theodore stayed back, and I think it was like maybe a day.
Was it Christmas time of 2015, 16, 17, 18? What year was it?
To be honest, I don't remember, to be honest.
All right, but it was prior to 2019.
Prior to 2019.
Okay. And in this picture, Fotis has very short hair, correct?
Yeah.
All right. Had you ever shaved Fotis's hair?
No.
All right. But you do recognize him in this picture?
Yes.
All right. Bob, can you pull up I-2? This is also a picture of Fotis?
Yes.
With one of his children?
Yes.
And even though the date's on there, can you tell or give a sense to the jury if, in fact, that seems like a picture taken of Fotis and one of his children in 2016?
Yeah, it was probably at the pond, it looks like, maybe. And the one in Avon, I don't know.
But about that year? Does that year seem right?
The way Petros looks? Yeah.
All right. And Bob, can you please pull up I-3? Do you recognize Fotis in this picture?
Yes.
And with his children?
Yes.
Was this also at the pond?
I can't really tell.
But was this prior to 2019?
Yes.
Bob, you can take that down. Thank you. You told the jury that you stayed behind in Miami in March of 2017 for a little while?
When Jennifer went back home?
Yes.
Yes.
And then you returned at some point?
Yes.
Without Fotis?
Without Fotis.
And Jennifer told you that she confirmed that Fotis was having an affair?
Yes.
And she didn't seem surprised?
No.
And she said she wasn't in love with him and hadn't been for a long time?
Yeah.
Jennifer also told you when you were in Florida that she suspected Fotis was having an affair.
Yes, she did.
And you didn't believe her at first.
No.
And you had worked with him for several years before,
Yes.
side by side,
Yep.
and you thought you knew him.
I thought I knew him.
Did you know that Fotis had been married before Jennifer?
At that time in 2017, yes. But it took me some time to find that out.
All right, but you eventually learned that?
Yes.
That he in fact was married before?
Yes.
And he was dating Jennifer while he was still married?
I didn't know the details.
Okay. Did you learn that at some point?
No, I didn't.
Okay.
So, before you proceed, counsel, the court has to take a brief recess, not based on anything other than something has been brought to the court's attention. So, this is not the afternoon recess, ladies and gentlemen. This is just something the court has to address immediately. So we ask that you return to the deliberation room and please do not discuss the case. We'll take, everyone needs to leave the courtroom.
All rise. This Honorable Superior Court now stands in recess. Please exit the courtroom. We're now opening back the session.
Please be seated. Thank you.
I think the doors are still locked, Judge.
Do we have internet on that thing or not?
Yes, yes.
Shouldn't be.
No, you can't.
I have it airplane mode right now.
Can we switch it back to airplane mode before? We,
Yeah. No, I figured it all
I
out.
just want to do a little research. Okay. Just want to make sure there's no missteps here.
You're in.
That's right. That would be the. That's the discharge.
Are we on the record, Madam Monitor? The court indicated before it took that brief recess that it had to address a matter. And the court has to address that matter at this time, which has nothing to do with the merits of the case. The court was informed previously that one of the marshals had, in the presence of two of the jurors, rendered a complimentary remark to Attorney Liz Moran outside of one of the elevator banks. And that complimentary remark was that, according to what was reported to the court, we love you. But the attribution to the marshal was an incorrect attribution. The court has now learned that it was not the marshal who said, we love you to Attorney Moran, but it was one of the jurors. That is cause for the court to have to bring in that juror to determine whether those remarks were made. And if those remarks were made, then that juror may have to be dismissed. But first, we will ask Mr. Christian Alvarado to just take the stand so that we can understand what the nature of those comments were as he heard them. The court should also indicate that when the juror is brought in, there will be no video coverage of that, no still photo coverage of that, and we would ask both the videographer and the photographer to wait outside of the courtroom when that juror is brought in. Madam Clerk.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give regarding this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Just state your name.
Christian Alvarado.
Thank you. Marshal Alvarado, you may be seated. Marshal Alvarado, the court will just draw your attention to the time before we took our lunch and recess, and you were in the presence of at least two jurors after the court had recessed. Can you tell the court what happened and what you heard?
I was on the elevator coming back from lunch with the two jurors, and it made a stop on the second floor. Attorneys Moran and Manning tried to get on the elevator. They turned back around. And in the midst of that, I said, thanks, Liz. And the juror ultimately kind of stuck his head out and said, we love you. The door closed. And then we went on our way.
Now, was that juror's comment directed towards Attorney Moran?
I believe so, yes.
And how many other jurors were present when that comment was made?
Other than him, just one more.
And was there any other marshal with you when those comments were made?
Just me.
Was there anyone who was not a marshal or a juror close enough to hear those comments?
Not that I could see from my point of view.
Okay. Thank you. You may step down. Yes. Now, what the court is going to do at this point is call that juror in. The cameras need to go off. And we ask the videographer and the photographer to step out of the courtroom.
Honorable Superior Court is now opening back to session. Good afternoon, Your Honor.
Before we call the hearing in, before we proceed with further evidence, before I make the record as to what has transpired. It was brought to the court's attention when we began our afternoon session that there were some comments made by what was believed to be a marshal that was heard by some jurors who were sitting on the case. It was later discovered that it was not the marshal that made those comments. It was one of the jurors who made the comment. Now, the comment was directed towards, as the court understands it, at least one person, Attorney Elizabeth Moran, who is one of the assistant state's attorneys who was assisting the state in the presentation of exhibits. The comment made by one of the elevator banks in the presence of another juror and one of the marshals, or the marshal that was involved, was that we love you, directed at least to Attorney Moran. Upon learning that the comment was made and that it was made by one of the jurors, the court conducted an inquiry calling that juror to the courtroom and having that juror sit in the jury box. And the court asked the juror if he made such comments, and the tenor of the response was yes. The comment was directed at both Attorney Moran and Attorney Manning. And the court indicated to the juror that it can easily be perceived that the comment made to at least Attorney Moran can be an endorsement, an opinion about the strength of the state's case, and that he at this time was favoring the state's case. The court explained to the juror that the appearance that there was a favorable opinion of the state's case indicates to this court at this time that it would be difficult to proceed with him seated as a juror because the impartiality and fairness of that juror can reasonably be questioned. That was juror number 420. The court dismissed the juror. The court then asked that the juror who was in the presence of that juror, who also heard the comments, to be seated in the jury box. The court asked that juror if those comments were discussed with anyone else, that is, anyone on the jury. And the response was no, and the court asked if those comments were heard by anyone other than himself, juror 399, and of course, juror 420, and the response was no. Because the inquiry involved an inquiry of jurors, the court maintained its supervisory authority not to have that portion of the proceeding recorded, either by video or by audio, other than the court reporters taking of the audio of the proceeding. Are we ready to proceed?
Yes, Judge.
We can let's bring the jury back in. Well, we can bring the witness in first, and then we'll bring the jury in. You may inquire, Attorney Felsen.
Your Honor, I have to wait for the
Oh, I'm
jury.
sorry. Please bring the jury in. Counsel stipulate.
Yes, Judge.
Yes, Your Honor.
Thank you, may inquire.
Thank you, Your Honor. Good afternoon again. We keep getting interrupted.
Yes.
Apologize.
All good.
I want to just close something out. And if I had asked you already, and I'm repeating it, I apologize, but maybe I missed it. I think you said at some point in time you did not know that Fotis had been married previously. Did at some point you learn that?
I learned it at some point.
Okay. Do you remember when you learned that?
It was a few years after working for Jennifer and Fotis.
Okay. It was before 2017?
Yes.
All right. And did you learn that he was still married when he was with Jennifer?
I'm just going to object, Your Honor. Asked and answered, calls for hearsay.
Well, the question was, what occurred, the word believe, that he was still married? So the court did not catch the phrasing, Attorney Felsen. Would you phrase the question again as you stated it?
At some point, did you learn that Fotis was still married while he was dating Jennifer?
Same objection, Judge.
Well, did you learn that Fotis was still married while he was dating Jennifer? And the objection is?
Well, it's twofold. One is that she's already answered this question, so it's asked and answered. And then my second objection is that it calls for hearsay information.
Well, the objection's overruled.
You can answer.
No.
Okay. After you came back up from Miami and Jennifer had told you that she was going to leave, she asked you to go with her?
It wasn't right. It wasn't that night when I got back, no.
Okay, but it was shortly after that.
A few weeks after.
And you said yes?
Yes.
And you gave notice to Fotis that you were quitting 4 Group?
Yes, I did.
But you didn't tell Fotis that why you were quitting, right?
No.
And the plan was for Jennifer to move out of Fort Jefferson?
The plan with myself or the plan with like that? her
Just
and
with
Fotis?
Jennifer to move out.
Her plan was to no longer live at Fort Jefferson.
Okay. And to leave without Fotis knowing that she was going to leave?
she was going to let him know after she left. So, yeah.
So she was going to leave without him knowing that she left. And she was going to take the children without him knowing that she was going to take the children.
Yes.
And she told you not to tell, obviously, Fotis, right?
Yep.
You had testified to some, there was tension in the house, right? Between, I would say, when you got back from Miami and then when Jennifer moved out.
Yeah, so like the months prior to her leaving.
All right. And there was also some tension between you and Fotis, where Fotis had yelled at you.
Yes.
In 2017.
Well, the tension with Fotis and myself didn't really start until after, well, the day I left with Jennifer.
Okay. So from about June of 2017, for at least that month, there was some tension?
Probably a few months after that.
All right. And you had testified that you saw him here in court?
I did.
It was in this courthouse?
Yes.
And he approached you?
He did.
And he was angry?
Yes.
And then his personality shifted and he appeared to be reasonable?
Yes.
And he also had approached you once at the pond, I think, and had been yelling at you?
Yes.
And then suddenly switched and became very reasonable?
There were several times in which he yelled at me, different occasions of drop-offs.
And then his personality just shifted?
Yeah.
And those were in 2017?
Yes.
And because of that, you had indicated to Jennifer that you no longer wanted to have contact with Fotis?
Yes.
So between 2017 to 2019, you had very little contact with Fotis?
Yes.
All right. You didn't go to Fort Jefferson?
No.
You didn't know who was living at Fort Jefferson?
No.
You didn't talk to Fotis on the phone?
There might have been a few occasions. They were going to a family systems therapy where I would do some drop-offs, but that was more controlled. So occasionally I would do that. But there was never really any like calls or texts between Fotis.
Okay, so for 2 years, other than those few times, you really had no interaction with him?
No.
So I'm going to fast forward now to 2019, to May of 2019. You were still working for Jennifer?
Yeah.
And Jennifer was living in New Canaan?
Yes.
At some point, she moved to 69 Wells?
Yeah, she originally moved to 153 Chichester, which was in New Canaan. And I think it was a year she moved to 69 Wells Lane.
And when she was at 69 Wells, you were working, doing childcare?
Yes.
And you were helping organize the house?
Yes.
In May of 2019, were the Dulos kids and Jennifer living at 69 Wells?
Yes.
And in May of 2019, did Fotis have supervised visitation with the children?
Supervised, yes.
And that was on Wednesdays?
Wednesdays. And if it was agreed upon other days, for like that Memorial Day weekend, he was supposed to have a visit on Saturday. But that's because it was agreed on before. So there was some flexibility if the supervisor and Jennifer, they all agreed.
All right. And you're talking about the Saturday of Memorial Day weekend?
Yes.
All right. So the Wednesday before it, let's go to the Wednesday before it. That was May 22nd?
Yep.
And did Fotis have scheduled visitation with the kids on that Wednesday?
Yes.
And it was through a court-ordered supervisor?
Yes.
And that court-ordered supervisor would be present when Fotis met with the children?
Yes.
And spent time with them? And that had been happening for many weeks prior?
Yes.
That Wednesday, May 22nd, Fotis had a supervised visitation with the kids?
Yes.
And it ended up being at 69 Wells?
Not the whole visit.
But part of it was at 69 Wells?
Part of it.
And Jennifer had agreed to your understanding to allow him to be outside in the backyard at 69 Wells?
Yes.
All right. You didn't want to be there?
No.
And you weren't there while Fotis was there?
No.
So you didn't see Fotis interact with the kids that night?
No.
And you didn't see Fotis interact with the supervisor that night?
No.
And you didn't see Fotis interact with Jennifer that night?
No.
So that's Wednesday, May 22nd. Thursday, May 23rd, you worked a regular schedule?
Yes.
You were in the house?
Yes.
And I think you had mentioned that that Thursday you had emptied out paper towels into the pantry?
Yeah, the evening before I left that Thursday.
And there were several of them?
12.
It was a package of 12?
Yeah, it was the big packs.
Is there more than one pantry in the kitchen, or is there just one main pantry?
One main pantry.
And is that the pantry where food is also stored?
Yes.
And the kids' water bottles?
Yep.
And there's no other pantry, just that one?
There's like cabinets and stuff, but the food pantry was just that pantry, yeah.
Okay, and the paper towels went in that pantry?
Yep.
All right. Now, May 24th is that Friday before Memorial Day. You had indicated that Fotis had scheduled visitation with the kids for that weekend?
That's Saturday.
Okay, did he also have it for Sunday?
I don't remember.
All right. And that would have been through the courts?
Yes.
By agreement?
Yes.
That Friday, you got to 69 Wells at about, did you say 11 a.m.?
Yeah, around there. I don't know exact time.
And you didn't expect Jennifer to be home?
No.
Because she had plans to be in New York?
Yep.
And you understood that she had doctor's appointments in New York?
Yes.
And you were going to meet her in New York later in the afternoon?
Yes, I was going to meet her at her mom's.
After you picked the kids up from school?
Yes.
That Friday, they had a half day?
They had a half day.
Because of the Memorial Day weekend?
I think so. I don't really know.
And you went to the house before you picked up the kids?
Yes.
I think you testified that you went in through the garage?
Yes.
Through the middle bay of the garage?
Yes.
Do you remember when you got there that there are 3 garage bays?
Yep.
All 3 of them were closed?
Yes.
And you remember that?
Yes.
And you used the keypad to get in that morning? And that keypad is only for the middle bay?
Yes.
All right. And when you opened it, you saw that the Range Rover was parked in the middle bay?
Yes.
And that was not what you were expecting?
Yes.
Because you had expected that Jennifer was going to take the Suburban?
No, she was going to take the Range Rover, and the Suburban was going to be left.
Okay. So you saw the Range Rover there, and that wasn't what you expected because you expected that would have been gone by that time of the day?
Yes.
Normally, so there's 3 bays, and the Range Rover was in the middle bay.
Yes.
Does Jennifer park the Suburban in the left bay?
Yes, on the left side.
Okay, she always does that. That's just what
always,
she does.
Yeah.
Even if she's running in for 5 minutes.
Yeah, it's always that one. It was impossible to park in the other one because of the other stuff that was in that bay. It wouldn't have fit through the 3rd bay.
The kids' stuff?
The kids' stuff.
Got it. And you had indicated when you walked through the garage that first time when you were walking through, you were going inside. Were you going inside just to straighten up before you picked the kids up?
Yeah, I had the sandwiches with me, so I put them in the fridge. And then, I usually go before I pick up the kids to straighten up.
And you didn't notice anything unusual in the garage when you first went through?
Other than the Range Rover being there, no.
You weren't really looking for anything?
I wasn't looking, yeah.
Did you go, when you walked in, did you go to the right of the Range Rover or to the left, if you remember, to get up to the garage door leading into the kitchen or the mudroom?
Yeah, so I always go to the right because usually the Suburban's there, so it's kind of just habit to go on the side that's empty that leads through the door into the mudroom.
And that door was unlocked?
Yes.
And it's usually unlocked?
Yes.
So that wasn't unusual?
No, that wasn't unusual.
So when you went inside, you had said that you saw Jennifer's purse in the house on the floor?
It was in the doorway between the mudroom and the kitchen.
And usually she has it on the counter or she takes it with her?
Yes.
So it was on the floor and that was an unusual thing?
Yes.
But you didn't go through it at the time?
No, I didn't go through it.
Did Jennifer usually bring her purse with her when she was traveling?
Traveling like to New York?
Traveling
in general?
Yeah.
It depended. Like she would take her wallet and phone sometimes. Just she would leave her bag somewhere else. It just wouldn't really be on the floor.
So that was unusual.
Having the bag on the floor was unusual, yeah.
And you saw when you walked in, there was an uneaten granola bar on the counter?
Yeah, it was like still in its packaging.
Right, you put that away?
Yes.
And then there was a mug of tea?
Yes.
And it was full?
Yep.
You washed that mug?
Yep.
The tea wasn't hot. It was semi-warm.
It was semi-warm.
And about what time was that?
Like close to 11.
All right. After you washed the mug, you noticed that there were no more paper towel rolls?
Yes.
So you went and replaced that roll of paper towels?
I just went to go get a new one in the pantry.
Do you recall there being a paper towel holder on the island in the kitchen?
Yes, it was right next to the sink.
And is that what you did? You replaced the roll that was on there, the used up roll, and replaced it with a new roll?
Yes.
And then you left to pick up the kids?
Yes.
You went back through the garage?
Yeah, I went through the mudroom, out the middle bay, closed the door, and got in my car to get the other kids.
And then you picked up 4 of the kids?
Yep.
And brought them back?
I brought the 4 back to the house.
The 4 kids, you went back through the garage?
Yes, we always went through the garage.
When you left to pick the kids up, did you shut the garage door?
Yes.
And then you entered the keypad?
Yes.
And you went back in?
Yes.
Do you recall if the 4 children went to the right of the Range Rover and walked into the house that way with you?
I don't recall. I don't
but
remember.
All 5 of you from school went back into the house?
Yes.
And there was nothing unusual at that point in the garage?
No, we just went right into the mudroom.
Got it. And again, you weren't looking for anything at that point?
Yeah, that's correct.
At some point, did you notice that there's another mudroom door leading to the outside?
Yes.
Did you notice that door was unlocked?
Yes.
That's unusual, right?
That was unusual, yes.
It's usually locked?
It's usually locked.
Especially that time of day?
Yes. The only time it was unlocked was when the kids were playing outside because it was right directly towards the backyard. But other than that, that door was always locked.
So you eat lunch there?
Yes.
And then you brought the kids to New York?
Yes.
Everybody went back through the garage?
Yep.
So it was the 5 of you went back
And myself
through the
and
garage.
4 of the kids.
And then did you shut the garage door when you left?
Yes.
At some point during the evening, you became very concerned and you called the police.
I did.
And you were giving them information, not just then, but over the next couple of days. You were talking to them and cooperating with them.
Yes.
During that time, when you were talking to the police, Fotis was reaching out to you. He was texting you.
Yes.
Can you pull up States 12?
16.
16. That's it. Is that the first page of it? Can you go to the next page? That's not what it is. I think it's, may I have one moment, please? So it will be 2 within that disk. These are your communications with Fotis, right?
Yes.
He was reaching out to you while you were talking to the police?
Yes.
And is this the first time he communicated with you? I can't see on top what time it says.
No. I had a phone call with him before that.
Okay. Bob, can you scroll down? Keep scrolling. Keep scrolling. Maybe the next page. Okay. Can you see where it says, "Good morning, GM, Lauren, any news?"
Yep.
All right. And you had said to him, called them at 2:30 and 5:30. No news. They just told me they're still searching.
Yes.
And then Fotis texted to you, "I spoke to an officer at 1 a.m. as well." What did you take that text to mean from Fotis?
I spoke to an officer at 1 a.m. as well. I read it as he called them, as I did, to speak to them.
And you spoke to the police and told them that you were talking to Fotis or communicating with Fotis, right?
Yes.
And did you learn that Fotis, in fact, was not cooperating with the police afterwards?
No.
You did not learn that?
Can you repeat that?
It was poorly worded. Did you learn that Fotis, in fact, was not cooperating with the police?
At that moment?
After
that moment?
Yes.
And days, we learned that he was not cooperating.
Okay, even though Fotis told you he spoke with an officer?
Yes.
All right, thank you. He was also texting you on Sunday because it sounds like he was asking you how things were doing.
Yes.
And he actually showed up in New York.
He did.
He drove down in his car.
Yeah, he drove, I believe, in his Suburban.
And that was where the children were staying?
Yes.
You were there?
I was there.
And it was an apartment?
Yes.
There's a bellman downstairs?
Yep.
Did he demand to see the children?
Yes.
Saying they were abducted?
Yes.
You'd said that Fotis water skied a lot.
He did.
Very competitively.
Yeah.
But that he was competitive with everything.
Yeah.
He was also a runner. You've seen him run before?
Yeah.
One moment, please. I don't have any other questions. Thank you.
Is there a redirect?
Yes, Your Honor. Good afternoon.
Good afternoon.
Ms. Almeida, you were asked some questions on cross-examination regarding Mr. Dulos' travels. Do you recall those?
Yes.
And I believe you were asked whether or not you understood what he was away for, whether it was vacation or business. Do you recall that question?
Yes.
Now, in the time that you worked for Group, you indicated that you had an opportunity to work on different projects for the company. Is that correct?
Yes.
What states did Group develop houses in?
Connecticut, and I knew that they built a house in Rhode Island.
A singular house in Rhode Island?
Yes.
You were asked some questions about the Miami Ski Club on cross-examination. Do you recall that?
Yes.
When did you first meet the defendant, Michelle Troconis?
It was at the ski club shortly after we got to Miami. I don't remember the exact day.
In March of 2017?
Yes, March of 2017.
May I ask the defense call up defense I-4? apologize. I should have given you the heads up. Ms. Almeida, do you recall being asked on cross-examination whether or not you took that photograph?
Yes.
Just direct your attention to the date, October 17th, 2016. Assuming that that date and time is attributed to that photograph, could you have taken that photograph?
No.
Thank you, sir. You were asked on cross-examination whether or not the defendant had moved to Vail, Colorado. Do you recall that question?
Yes.
Where did the defendant move?
Farmington, Connecticut.
Where in Farmington, Connecticut did the defendant move?
4 Jefferson Crossing.
How long after Jennifer moved out of the house did the defendant move into 4 Jefferson Crossing?
From what I was aware, a few months
Objection, Your
after.
Honor.
Oh, grounds.
Basis of knowledge.
So foundation. Well, counsel.
Well, I think it's fair follow-up to the cross-examination, Judge.
Well, the response, as the court understood the response, is from what she understands. And so the court does not know the fount of that understanding. And so the court is going to sustain the objection.
How did you become aware that the defendant had moved into 4 Jefferson Crossing?
Jennifer hired a private investigator and had pictures.
And when was that?
I don't know the exact time.
Approximately.
It was like a few months, maybe up to 6 months after the divorce started.
I just wanted to clarify, you were asked on cross-examination whether or not you'd ever been on vacation alone with Mr. Dulos. Do you recall that question?
Yes.
Have you ever been on vacation alone with Mr. Dulos?
With the kids, never myself and Fotis.
Right, and that's what I'm getting at. There were never just the two of you, correct?
No.
And you were asked some questions on cross-examination regarding Mr. Dulos' arrival in New York on Sunday, May 26th. Do you recall that?
Yes.
Could you just indicate to the jury what he was claiming?
He was claiming that we kidnapped his kids and that he was demanding the bellman to let him up to get his kids, which we already instructed the bellman not to let him up because at that point in time he didn't have custody of the kids.
If I could just have a moment, Judge. I'm sorry, if I could just have one moment.
Yes.
Did the Dulos children ever reside with their father after May 24th, 2019?
No.
Was there a scheduled visit for Sunday, May 26th, 2019?
I'm not sure.
Thank you. Nothing
One
further.
moment, please, Your Honor. I have no further questions. Thank you.
Thank you.
Okay, you may step down. Does the state intend to call another witness?
Yes, Judge. Just before we do, may we approach with a brief sidebar?
Yes.
Find my directive.
Out in patrol, where I worked various shifts. From there, I was a member of the special response team for about 10 years. And then in about 2016, I was assigned to the investigation section.
And when you say special response team, what's that?
Special weapons and tactics. It's a team that's comprised for various events that could occur, barricade subjects. You receive special training in tactics and weapons use.
And the investigations division, what type of cases do you work on?
Investigations handles any involved investigation, burglaries, bank robberies, death investigations, any investigation that will be of like a prolonged time that patrol typically wouldn't have the time to handle. It will get assigned to the investigation section.
And how long had you been working in investigations prior to May 24th, 2019?
I was assigned in October of 2016.
Were you working on May 24th, 2019?
I was.
And specifically the evening hours, I'll just call your attention to approximately 7 or 8 o'clock in the evening. Were you working a normal shift at that time?
I was not working my normal shift.
Okay, so I guess I'll ask the question, how did you end up becoming involved in this case?
Yes, so I had worked my normal shift, which was 8 a.m. to 4 p.m. during the Friday, and I was the on-call investigator. So I was contacted by Lieutenant Ogrins at about 8 p.m. that evening in regards to a missing persons report.
And were you initially, on behalf of the New Canaan Police Department, I guess, the lead investigator?
Initially, yes.
So when you received the call from the lieutenant, what was the next step that you took?
Lieutenant Ogrins contacted me initially to request if I could do a search of our license plate readers. I had access to that at the time, to search for the license plate of the missing person's vehicle. So I started to do that and then was contacted a short time later to report that they had located the vehicle on Lapham Road, and then they requested my assistance.
And who was the missing person?
Jennifer Dulos.
After learning that the vehicle had been located on Lapham Road, what did you do next?
I then responded to police headquarters, obtained my gear, and then went to where the vehicle was located on Lapham Road.
Prior to responding to Lapham Road from police headquarters, did you request any assistance from any other detectives?
Yes, I requested assistance from Detective Sergeant Romano, who was newly assigned to the Detective Bureau. And part of the training process was he would get called out along with any of the on-call investigators. So I had called Detective Sergeant Romano to come in to assist.
And did he respond to Lapham Road separately from you, or together?
Yes, he did.
When you arrived at Lapham Road, what did you see?
I met with Officer Blank, and there was Jennifer's black Chevy Suburban that was parked on the side of the road.
And at the time of your arrival on Lapham Road, was there an active search of Waived Park going on?
Yes. At that point, a canine from Wilton had been there to do an initial search of the area.
And Waived Park, what type of park is that?
Waived Park is a approximately 300-acre park in New Canaan that's comprised of various open spaces, sporting fields. There's what we call Waveney Castle, which is utilized for various events. It's a large open area for the townspeople to utilize.
And approximately how long were you at Lapham Road for?
Approximately 10 minutes.
Did there come a point in time where you responded to 69 Wells Lane?
Yes, I did.
Approximately what time did you respond to 69 Wells Lane?
That was about 10:10 in the evening, 10:10 p.m.
And when you arrived at 69 Wells Lane, how did you approach the home?
So I was informed by Lieutenant Laderette of some suspected blood that they had observed on a vehicle in the garage. So I met with Lieutenant Laderette at 69 Wells in the driveway.
And you're referring to him as Lieutenant Laderette. In fact, he was a sergeant at the time, correct?
That is correct, yes. I apologize.
Other than Lieutenant Laderette and Sergeant Laderette, was anyone else present at 69 Wells?
At that time, no.
What did you do once you arrived?
Sergeant Laderette, at the time, he had directed me into the garage. It was a 3-bay garage with a vehicle in the center bay, and he pointed out what he had observed to be possible blood evidence on the vehicle.
And did you observe it as well?
I did.
Could you describe it for the jury?
So I had brought with me a large lantern spotlight, and when I utilized that to light up, to illuminate the side of the vehicle, you could see signs of wiping, like a car that had been dirty but then had been wiped. As we walked around, noticed, droplets of a red color on the side and on the front.
Attorney McGinnis, just for clarity, could you inquire as to which vehicle
This was.
about?
Sorry.
Yes, sir. Which vehicle are we referring to?
There was a Land Rover that was parked in the center bay of the 69 Wells garage.
After observing the blood-like objects and the car, the vehicle, what did you do next?
So we continued to walk around the interior of the garage where we located some more blood, suspected blood evidence. And it was at that point then that we stepped out of the garage and made the decision to secure the home.
Where did you see the additional blood evidence?
As we walked around
Object to the word blood, and I think it's suspected.
Thank you. Well, there's an objection sustained.
Where did you see the additional blood-like evidence?
There was a what appeared to be a partial shoe impression on the concrete floor. There were 2 garbage cans inside the garage that, upon further inspection, the left-hand portion of the lid had suspected blood on that. Those blood droplets had a texture to them that was consistent to a texture that you would see on a kitchen rubber glove. There was a suspected blood droplet on the driver's side rear of the Land Rover. And then some areas on the concrete floor that appeared to have been blood evidence, suspected blood evidence that had been wiped up, cleaned up.
You mentioned a garbage can, I believe.
Yes.
Did you ever open either of those?
I did. I opened up both garbage cans and did a cursory look on the inside, and there were white, typical household garbage garbage bags that were in either one.
Now, after your observations, was the decision made to apply for a search warrant?
Yes. At that point, we stepped out, we secured, we consulted with our supervisors at the time, and I had made the decision that the Connecticut State Police Major Crime should be contacted for us to assist in processing the scene.
And the state police, they will routinely assist police departments like New Canaan with processing crime scenes if requested, correct?
That is correct. They have the resources, the manpower, and the knowledge and experience to do that.
And in New Canaan, you all work with the Western District, is that correct?
That's correct.
Now, as you were awaiting state police arrival, where were you?
We were in the driveway.
Was anyone allowed in the home?
No.
Approximately what time did the state police arrive?
Approximately between, I would say, the hours of 1 a.m. to 2:30 a.m.
And did someone from the state police named Sergeant Al Bisson arrive?
That's correct, yes.
And what was Sergeant Bisson's role with the state police?
Sergeant
Your Honor,
Bisson.
I'm going to object. It's cumulative, and this witness would only know from hearsay what another person's role from a different department was.
Well, the question is, what was Sergeant Bisson's role with the state police? No, that's not the same as what did Sergeant Bisson do. So it's sustained.
Did you speak with Sergeant Bisson?
Yes, I did.
And did Sergeant Bisson, on behalf of the state police, make any offers to you?
He did. Sergeant Bisson was the supervisor of the Western District Major Crime Van at the time, and he had offered his services and also offered if I needed any other investigators or detectives for assistance.
And when he's offering any other investigators and detectives, he's offering state police personnel, correct?
That's correct, yes.
After he offered you this additional assistance, did you ultimately accept it?
Yes, I did.
And so as the night continued, the state police are arriving.
Yes.
Did you begin to receive information about a potential person of interest in the disappearance of Jennifer Dulos?
Yes, we had.
And who was that potential person of interest?
That was Fotis Dulos, her husband.
And who informed you of this information?
That was from the initial initial officers that had taken the missing persons complaint, Officer Kelly Coughlin.
And was Officer Coughlin working dispatch that night?
That's correct, yes.
Meaning that she's actually receiving 911 calls and things of that nature?
Yes.
And did you end up speaking with Mr. Dulos that night?
Not that evening. I spoke with Mr. Dulos the following morning. Sergeant Ferenga had spoken with Fotis Dulos that evening.
Now, I want to direct your attention to the following morning. Was there a command post set up at the New Canaan Police Department?
Yes, there was.
And what floor of the New Canaan Police Department was that located on?
The second floor in the investigations office.
And who was present at the command post in the early morning hours of May 25th?
Myself, New Canaan Sergeant Condos, New Canaan Sergeant Romano, New Canaan Sergeant Ferenga, Sergeant Al Bisson, Connecticut State Police. There was also Detective Chris Allegro, as well as several other Connecticut State Police detectives.
And Detective Allegro, what unit of the state police was he with?
Western District.
Was he with the van or major crime?
Major crime. Major crime detective.
Now, at some point on the morning of Saturday, May 25th, did you make contact with Mr. Dulos?
Yes, I did.
How did you make contact with Mr. Dulos?
I had made a call to his cell phone.
Do you recall how you got his phone number?
That was delivered to me from previous coworkers that had already spoken with him.
And did you make any requests of Mr. Dulos during that call?
I had asked if he would be willing to come down to the New Canaan Police Department to speak.
And did he agree to do so?
Yes, he did.
Did the two of you agree on a time?
Not a specific time. Fotis had stated that he was in a meeting and that it would take him approximately an hour and a half to travel from Farmington to New Canaan.
And from the moment that you were speaking to him, what would have been an hour and a half?
So that was at approximately 9:30 a.m. in the morning.
So
11.
He would have arrived at approximately 11 had he left?
Had he left at that time, yes.
Was it your intention to interview Mr. Dulos with any other detectives?
Yes. Detective Chris Allegro from Connecticut State Police Major Crime.
And did Mr. Dulos arrive at 11 a.m.?
No, he did not.
I want to direct your attention now to approximately 12:30. Were you contacted by anyone on Mr. Dulos' behalf?
Yes, so at approximately 12:30, I had noticed that I had a missed call on my work telephone, and then I had also received an email from an attorney associated with Fotis.
And what was the attorney's name?
Jacob Prytanker. Prytranker.
And were arrangements made with Mr. Prytranker for Mr. Dulos and he to come to the police department?
Yes.
And did he indicate that he'd be accompanying Mr. Dulos?
Yes, he did.
Was there an agreed upon time that they would arrive?
Just that they would be down possibly around 2:30 p.m.
Now, I want to direct your attention now to approximately 2:40 in the afternoon. Did you receive any notifications from the New Canaan Police Department front desk?
Yes. So the dispatcher at the time had called my desk to inform me that there were two persons in the lobby that were looking for me.
And did you go to the lobby?
Yes, I did.
Who, if anyone, did you go to the lobby with?
With Detective Allegro.
And when you entered the lobby, who did you see?
Fotis Dulos.
Could you describe Mr. Dulos' physical appearance for the jury?
Yes, he was dressed dark-colored pants, shirt, a sport blazer he was wearing.
And did you, Detective Allegro, and Mr. Dulos exchange pleasantries?
Yes, yep, we introduced ourselves.
Was Mr. Prytranker in the lobby at the time that you exchanged
No, he
pleasantries?
was not.
Where was Mr. Prytranker?
We had asked Mr. Dulos if his attorney was with him, and he had motioned to outside of the police department, and there was an individual outside pacing back and forth on a cell phone, and he had motioned that was his attorney.
When you say he's outside, did the lobby of the New Canaan Police Department have windows or?
Yes, there's windows, and there's the door is glass, so you can see outside to the parking lot.
And how is Mr. Prytranker dressed?
Professional suit.
Now, did Mr. Dulos offer to go get Mr. Prytranker?
So he stepped outside to go get him, and he returned back into the lobby again without the attorney.
And was there any conversation at that point about the police department being a secure area?
So I had informed Mr. Dulos that we would be going to sit down to talk is in a secured area, and that I would just need to ensure that he didn't have any weapons or anything on him. To which at that point he removed his wallet and keys and started to search for his phone.
And as he was searching for his phone, did he say anything?
Just he was initially looking for his phone, didn't know where it was.
Now, after Mr. Dulos was looking for his phone, did Mr. Prytranker enter the lobby?
Yes, he did.
And what happened next?
As he entered the lobby, Mr. Dulos had seen that he was holding his phone, and he goes, "Oh, there's my phone." And Attorney Prytranker had handed it over to Mr. Dulos.
And this occurred in your presence?
Yes, it did.
What happened next?
At that point, Attorney Prytranker had informed us that Mr. Dulos would not be meeting with us at that point.
And so after Mr. Prytranker indicated that Mr. Dulos would not be meeting with you, what happened next?
As Mr. Dulos was going to put his phone into his blazer, Detective Allegro asked Mr. Dulos if he could see his phone.
And did Mr. Dulos give Detective Allegro his phone?
Yes, he did.
What happened next?
At that point, Detective Allegro observed that the phone was secured, was locked with the numerical code, and he asked Mr. Dulos for his passcode.
And did Mr. Dulos provide the passcode?
Yes, he did.
Did Detective Allegro use the passcode to get into the phone?
Yes, he did.
And after he used the passcode to get into the phone, what did he do next?
He then placed it into airplane mode and informed that the phone was being seized.
Now, in your experience as a detective, are cell phones sometimes seized in criminal cases?
Yes.
Objection.
Well, in your experience as a detective, are cell phones sometimes seized? Well, that question, to use a colloquial phrase, is loaded. Sustained.
What types of evidence from an investigative perspective can be found on cell phones?
Location data, phone calls, text messages, emails, pictures.
And when you say location data, what do you mean by that?
Anytime that a cell phone is used, it will record through metadata where the location that incident had taken place. There's various apps also that do the same. They will track your location. So either, for map guidance or whatnot.
Did you have a search warrant for the cellular phone at that time?
At that time, no.
Was one being drafted for the cellular phone?
Yes, there was.
Why was the phone seized without a search warrant?
Honor, I'm going to object to his subjective reason. We can get into the constitutional issues, but I don't think that's appropriate here. So I'm objecting on relevance ground.
Well, the short answer is going to be so that we could try to find what we wanted to try to find. That's the answer. The court's going to allow the question.
You can answer.
Can you just repeat the question?
I can try. Why was the cell phone seized without a search warrant?
To prevent the loss of any possible evidence that was on the phone.
After Detective Allegro indicated that the cell phone was seized, did Attorney Prytranker say anything?
Yes.
What did he say?
He had stated, why are you taking the phone, on what grounds, and asked if we had a search warrant.
And did Detective Allegro explain to him why the phone was being seized?
Yes.
At that point, did Mr. Prytranker and Mr. Dulos exit the police department?
Yes, they did.
And when they exited the police department, where did they go?
Outside, right in front of the main lobby doors.
Were the two of them still visible to you?
Yes.
And at some point, did Mr. Prytranker come back inside the police department?
Yes, he did.
And did he demand the phone back?
Yes, he did.
And did Detective Allegro indicate that he was not going to be getting the phone back?
Correct.
Did Detective Allegro subsequently turn the phone over to you?
Yes, he did.
And what did you do with the phone?
At that point, ensured that it was in airplane mode, and then obtained the serial number and the IMEI number for records.
And did you also log the phone into evidence?
Yes.
May I have this marked for, I believe it could be a full exhibit.
What's the number, please?
I think we're up to 17, Judge.
Stage 17, admitted, no objection, full exhibit.
May I just have a moment, Mr. McGinnis?
Detective Patton, I've handed you what's been entered into evidence as State's Exhibit 17. Do you recognize State's Exhibit 17?
Yes, I do.
What is State's Exhibit 17?
This is the cell phone that was seized from Mr. Dulos in the lobby of New Canaan Police Department.
And I'm just going to ask if you could just please take the cell phone out and hold it up for the jury. And what type of cellular phone is that?
This is an Apple iPhone
Do you know the model?
X.
We can put it back. And is this the cellular phone that was taken off of Mr. Dulos, or taken from Mr. Dulos? Was a search warrant subsequently sought for Mr. Dulos' cellular phone?
That is correct, yes.
And how does law enforcement get information off of the cell phone? In other words, do you guys do a visual inspection of the phone? Do you guys do a download of the phone? What's that look like?
No, it's done through a forensic digital examiner that would conduct a download of the cell phone.
And do you know a forensic examiner by the name of Michael Clark?
Yes, I do.
Is Michael Clark affiliated with any police departments here in Connecticut?
He's a detective with the Fairfield Police Department.
Did you take this cellular phone that's been entered into evidence as State's Exhibit 17 to Michael Clark?
I did.
Why did you take it to Detective Clark?
Detective Clark had forensic software and hardware that was available, and he was also available to process on Sunday, 26th.
So you took it to him on Sunday, the next day?
Correct, the next day.
And were you present for Detective Clark's download or extraction of the cellular phone?
I was.
And as the phone was being downloaded, were you able to see some of the information that was being downloaded?
So yes, after the extraction was complete and was uploaded into the software that then parses the data so that you can see the data, you were then able to begin to look at some of the data that was being parsed.
And I want to direct your attention now specifically to location data. Was there location data that was parsed that you were able to view?
That's correct, yes.
And can you just explain to the jury the location data that you observed that was of interest to you?
So I'm going to object. There's going to be, I assume, information concerning that. This is not only hearsay, but it's violation of the best evidence rule to have him testify as to what he saw on an extraction from a phone.
Well, the testimony so far is that the cell phone was taken to Detective Clark, who forensically downloaded it. And this detective observed location data. And the question now is what essentially else was observed that was of interest?
No, what of the location data was of interest? Like, in other words, parsing from what was actually the download, not something else.
Well, there has to be a foundation that Detective Patton can read extracted data from a cell phone. It's not written out in narrative paragraph form, so there has to be a foundation for that.
Detective Patton.
So the objection, as it is sustained.
Yes, Judge. Detective Patton, when you are when a phone is being downloaded, can you just explain to the members of the jury what the data looks like?
So when it's parsed into the software, it's grouped into categories so that you can easily search, such as pictures will be grouped into picture category, location data will be grouped into location data, text messages will be grouped into text messages. So you can easily navigate through the information that was retrieved from the phone.
And what software allows that to be done?
This was Celebrite.
And Celebrite is a software company that has created a mechanism to download cellular phones?
Correct.
And so when you were reviewing the location data, what type of data were you looking at?
We were focused on the date of interest is when Jennifer Dulos was reported missing.
How does the location data come up on the cellular phone? What does it appear as?
It's sorted by date and time.
I guess what I'm getting at is the location data itself. Is it latitude, longitude?
Latitude and longitude, and then the software will also give you a map.
When you say the software gives you a map, you mean it actually pinpoints where the cellular phone is at a particular time?
Correct, and it's displayed on a map similar to what you would see on like Google Maps on a phone. It shows you an actual, not a satellite image, but a default image of a map of the location.
So was there any location data of interest to you that you observed on the phone?
Your Honor, if this is just a yes or no, I don't object. It's the next question that I object.
So the witness may answer that.
Was there any location data of interest that you observed on the phone?
Yes.
What was that location data?
Objection.
Ground.
Hearsay, foundation, this is not the witness who can testify to that, and it's not the best evidence. It's my understanding if they have this data, they can produce it, but this witness simply can't say any more than you or I can say, oh, well, the computer produced this, and now I see certain things, so I object on that basis.
Well, the court's view is this. If the witness has testified that what is seen is a date and a map, then the witness can testify what he saw on the map. That is the witness's personal knowledge as to what he saw on the map. So overruled.
You may answer the question.
So we observed that there was a route that was taken to Albany Avenue in Hartford on the evening of May 24th.
And do you recall approximately what time that route was taken?
Approximately 7 p.m.
Where had the phone been in the morning, according to what you observed?
Could I just have a running objection to all of this?
Yes. Well, again, the court thinks the objection is well taken. If there's a map, then that map is either a point in time, or it's a map where you're looking at the course of a route over an extended period of time. So the question, what else, suggests to this court that what this officer observed is not simply a point in time on the map. So there has to be a foundation as to how he would determine where the device had been hours earlier.
How did you determine where the device had been hours earlier?
Through the location data of the phone.
And so, can you just explain to the members of the jury how you're able to do that?
Well, again, I'm going to object. He testified he didn't do it, and it's not even his program, so I think this is the wrong witness for that aspect of it. I certainly didn't object to the general explanation of what he brought and saw someone do, but now for asking him to interpret the data is where I object. I couldn't cross-examine this witness about specifics without actually having those documents through the witness who produced it. I may not require that person. I'm just saying I don't think he's the right person.
Right. Well, it would appear that the question the court would have is, how does this mapping of a device work such that you can follow it over the course of a number of hours?
Try to ask the judge's question. How does the mapping work so that you can follow it over a number of hours?
I'm not an expert witness in the behind the scenes of how the software was developed and how they gather the information to then present it. But my understanding is that...
Well, then I'm going to object to his then lay understanding.
Well, then the question is, how do you come to the conclusion as to Albany Avenue other than, well, the court does not even know what the answer is to other than. How did you come to the conclusion that the device was on Albany Avenue based on the forensic download?
You can answer that question.
Because the phone captures location data when it's being utilized, and then the software will parse that and easily show the location data in a chronological order, and you can follow that through and tab through each location, and it will then update you and show you the location that the phone was in on that particular date and time.
So the court understands the testimony to be that the forensic download will show a date and then perhaps longitude, latitude at a certain time. But it won't say the phone was on Albany Avenue.
Is that correct, sir?
That's correct.
So how do you determine where the phone is at that point?
By either inputting the lat and long into a mapping software, but Cellebrite also gives you the option that you can also see that. They pre-map it for you, so you can actually see on another screen the location.
And based on your observations of the latitude and longitude showing the phone near Albany Avenue, did you alert any other law enforcement personnel to that information?
Yes, I had reached out to the detectives that were back at New Canaan Police Department and elsewhere of the finding.
May I just have a moment, Your Honor?
Yes.
I have nothing additional.
So I take it, I'm not going to ask you a lot about that. I take it you are not an expert then in either the Cellebrite input or reading the data in its raw form, correct?
So I do have training and certifications in Cellebrite certified operator, and Cellebrite physical analyzer.
Mm-hmm. Did you have that in 2019?
I did, yes.
All right, but you didn't want to do this yourself?
At that time, I did not have the experience.
Oh, that's what I'm talking about. In 2019, you did not have the
Correct.
experience.
I started with the Technical Investigations Unit in 2018.
You started in 2018, but this happened in 2019. Are you saying, though, you did not yet have sufficient experience to be able to interpret it, right?
Correct.
So it's more like if somebody prints something out, I could look at some data and then try and follow the instructions and punch it in and come up with some locations, basically, right?
You're not coming up with the locations. The software does that.
The software does it. Okay, fair enough. So let me move away from that for a moment. I'm going to ask you about your earlier testimony. You said you went to Waveney Park. Is that right?
On Lapham Road near Waveney Park.
On Lapham Road, adjacent to Waveney Park, correct? And you said something about seeing Officer Blank there, right?
Yes.
And you also said you observed a canine dog, police dog, in the area of that
I did
car.
not observe the dog.
You did not. Then you just heard about it?
I was informed that there had been a dog there, yes.
Oh, so were you also informed that there were other canine dogs that had been dispatched from state police or from other police departments to also search?
Correct.
So you were, and so at that time, the chief investigator on this investigation, you're aware that Officer Blank then went into the woods with one of those canine units, correct?
Correct.
You know that they followed a scent to the Talmadge Hill Metro North station, correct?
Correct.
And that's where they lost the scent, right?
Correct.
You testified that either late on the night of May 24th or early in the morning of May 25th that Mr. Dulos had a telephone conversation with Sergeant Ferenga. Is that correct?
That's correct, yes.
Now, he's higher up now than a sergeant,
Correct.
right? But at the time, he was a sergeant,
At the time, he was
right?
sergeant, correct.
A uniformed officer?
He was in the Detective Bureau.
He was in the Detective Bureau at the time.
Correct.
And he received a call from Fotis Dulos. Is that right?
He had made the phone call to Fotis.
He made the call.
Correct.
And he spoke to Mr. Dulos for some time that night, didn't he?
I don't know how long, but he did speak with Mr. Dulos, yes.
And earlier than that, Mr. Dulos had actually called the New Canaan Police Department and spoke to dispatcher, that was Officer Coughlin, correct?
That's correct.
And that was shortly after, as I understand it, a Farmington police officer had notified him that his wife was missing, right?
Correct.
And that conversation went on for a little bit of time, didn't it?
I wasn't there. I don't know how long that was.
Right. Again, you were informed of that by, who was it, Officer Coughlin?
Yes.
And you were also informed about the longer conversation that Mr. Dulos had with Sergeant Ferenga, right?
Yes. I don't know how long the conversation was, but yes.
But you were made aware of it that night, is that correct?
Mm-hmm.
Thank you. Is that a yes?
Yes.
No further questions. Thank you.
Is there redirect?
No, Judge.
Thank you. Detective, you may step down.
Thank you.
Well, it makes sense to conclude today's proceeding. Attorney Manning, Attorney McGinnis, do you have the court is not asking who, but do you have your lineup ready for tomorrow?
Yes, Judge.
Could we have a quick sidebar about scheduling?
Right. Well, the court remembers what we discussed. So.
Yeah. I wanted to make sure that the jury was aware.
Okay. We'll inform the jury tomorrow. Okay. Ladies and gentlemen, that concludes today's proceeding. Thank you for your attention. We ask that you be ready tomorrow at 10 o'clock. Please do not discuss the case.
All right. This honorable court now stands adjourned.